Honorable conference participants, please take your seats. The conference will open in less than 5 minutes. Please note that there will be no scheduled coffee breaks, but coffee and snacks will be available on the first floor throughout the whole conference. Thank you. Cienījamie konferences dalībnieki.
Dear participants of the conference, please take your seats. We will open the conference in a couple of minutes. Would like to remind you that there will be no coffee breaks. The coffee and snacks will be served throughout the duration of conference on the first floor.
Please note that there will be no scheduled coffee breaks, but coffee and snacks will be available on the first floor throughout the whole conference. Please rise to honor the national anthem of Latvia by singing it together. Its text is available in your folders. Lūdzu jūs piecelties, lai kopīgā dziedājumā godinātu Latvijas valsts himnu.
Labrīt!
Good morning. Good morning, Madam Minister for Justice. Good morning, dear colleagues, justices, professors, dear participants of the conference. Welcome to the capital of Latvia, Riga. Welcome to the wonderful small guild and its main hall, which symbolizes the unity of Europe and also symbolizes the Latvian folk wisdom. So this is the intersection between the European values and Latvian folk wisdom, and this is, for me, a perfect venue for the discussion on Europe's shared values. The title of the conference is the role of the constitutional courts in specifying or concretizing the shared values of Europe. This conference marks the 20th anniversary since Latvia's accession to the European Union, along with other 9 new European member states that became the part of this value and legal union. Just now, a couple of months ago, the conductor of the Song and Dance Festival, Jurģis Cābolis, also conducted us singing the national anthem that has been very important as the national prayer for the Latvian people, the anthem that guided us through the difficult, tough times to where we are today, as we have rejoined the European family and have returned to the union of values and laws or rights. And through the Song and Dance Festival Code, or DNA, it is easier for us as Latvians to explain what are the core elements or values of our national identity, whereas our constitutional identity, the constitutional identity of the Latvian state and its constituent elements are much more complex legal construct that needs to be unwinded through the discussion or in the discussion with the European Court of Justice. Now, as regards to the official language use in the higher education, both the Constitutional Court of Latvia and the European Court of Justice underlined the special role of the official language of Latvia as the integral element or fundamental element of our constitutional identity. So this case shows very vividly that constitutional identity of a member state at the European level can harmoniously coincide with the supranational laws or legal acts and requirements therein. International conferences organized by the Constitutional Court of Latvia are traditionally a good platform for discussing values and generating new ideas on constitutional values. Today we are going to continue actually previous discussions with this thematic discussion, and we'll continue the series of discussions on 3 legal systems: national legal system, international law, and European law, and how these laws effectively interact. And the first phase was the European Court of Justice and Member State Court discussions, a series of discussions, United in Diversity, which started in Riga in 2021. The next phase, or the next conference in Hague, which informally was titled the Riga II Conference, was the event where Constitutional Court provoked a discussion on how national identity could be interpreted through the lens of the constitutional identity, or could be integrated in constitutional identity. And last year at the National Library of Latvia, we talked about the human rights, fundamental human rights protection charter, and the significance of these core values in the European case law. So finally, we are bringing this all together in today's conference, and we are bringing all 3 legal systems together at this conference to try to find the common denominators and shape the future of our common legal space or legal domain. We will have two panel discussions, the reconciliation of the national constitutional identities with the shared European values, and the second panel discussion on the European consensus as part of the European order. And we have very clear reasons for structuring our today's event this way. There's no doubt that the European legal system and laws, legal acts are based on shared European values, but there are also constitutional identity elements at the national level that can lead to actual or hypothetical interaction or clash between the national constitutional identities of the member states and European constitutional values. And this event is meant to bring together two schools of thought and how to discriminate real constitutional identity from other national values that unfortunately fall short of being considered constitutional basis of particular member states. And secondly, how constitutional identity elements need to be applied in order to achieve justice and sustainable or harmonized implementation across the European Union. And also considering that laws continuously evolve, I suppose this conference should also focus on doctrine assumptions about the inviolable core of the European values, which are safeguarded or are immune towards national constitutional identities. This is something that is, to me, worthwhile discussing. During the second session, we will talk about the European consensus, which is based on the European Court of Human Rights case law and doctrines that have emerged from this case law, which is a sustainable, or rather sustainably changing set of European values. As you can see from the recent case law, we can see that the European consensus has a direct impact on how these laws are applied and implemented. However, national courts still are keen to find out more what are the suggested methodologies when it comes to identifying the European consensus and how it interacts with our fundamental laws. The organizers of this conference, with future in mind, approached the participants with an interesting task of asking them to become visionaries and think about European consensus as a facility, as a mechanism which influences how we understand the content and European shared values. So we have challenged the participants to think about the European consensus as one of the integral elements of the European Union law and its evolution. I would like to also, in conclusion, touch upon two other significant aspects. Traditions have a very strong force. And just like before the pandemic, Riga conference is now held again in the first half of the year. With the spring in the air, we are filled with hope, and I am very much looking forward to the 2025 spring conference in Riga, next year's conference in Riga, which in scope of the Council of Europe project support for the development of constitutional justice in Ukraine will be held by the Constitutional Court of Latvia together with the Ukrainian Constitutional Court next year. Our Ukrainian colleagues, despite war, are not only continuing to work and fulfill their everyday duties, but also are evolving and have set the bar very high for Ukraine as a democratic country governed by the rule of law, a country which has rejoined the European family. And last but not least, on the quality of this conference, we have taken into account the suggestions of the participants, who are suggesting that sometimes we don't have enough time for the discussions at the conferences of this kind. And to me, discussion is the most valuable part of any conference and should serve the purpose of the conference. And that is why, not typically for conferences like these, we have plenty of time for questions and answers and for commenting. So you're very welcome to express your thoughts, since we have a lot of time. So I would like to wish you a very interesting and constructive discussion. I hope you'll get a lot of inspiration about how to harmonize all these three legal systems and ensure that they interact in an effective manner. Thank you, and have an interesting conference.
And now I give the floor to the Minister for Justice, Madam Ines Lībiņa-Egnere. The floor is yours. Good morning, highly esteemed President of the Constitutional Court, Mr. Loviņš, esteemed the Judge of the European Court of Justice of the European Court, Madam Ziemele,
Vice President of the Venice Commission, Mr. Coyer, augsti godājumās tiesneses, tiesneši.
Esteemed judges, colleagues, ladies and gentlemen, representatives of the academia. It's really honor for me to participate at the opening of such a conference, to greet you, to welcome you, and to speak at a conference which is dedicated to reinforcing and protecting our shared European values. And at the very beginning of this opening address, I would like to quote President of Latvia, Bairavīķa Freiberga, when in 2003 she addressed all those present at the ceremony for signing Latvia's accession treaty to the European Union. And she said, we have now future ahead of us, future that we are going to create all of us together, and we will have to meet danger and threats and challenges and discord. That's part of life. And we, all of us together, will have to take a stance against it, and it will be easier for us to reach a solution and answers, end of quote. And this year, 2024, this is a year when we are marking a very important anniversary, 20 years since we became full-fledged members of the European Union and NATO. Now, looking back, we can say convincingly that everything what the President said at the time has become true. We still have, and we have encountered threats and the danger, internal and external. We have also seen challenges and discord. And yet we have also had wonderful moments of unity. Excellent solutions have been found and the best answers in situations when these were really needed. It was not easy all the time, but it was much easier together with the support of our allies. Our constitutional identity, or the core of our constitution, is based upon human dignity, freedom, democracy, security, equality, the rule of law, human rights, and self-determination of the state, and all human rights. And all these are also the shared values of Europe, and these are embodied both by the European Union and the Council of Europe. We, all of us, are the creators and shape of these values, defenders, and we are also implementing them. These have not been imposed upon us. Latvia's participation in the space of European value has proven that these values, shared values, strengthen our country both on the national and international scale. Shared European values and aims is a very strong background and also a beacon which guides us when we make decisions on the national level. This also inspires us. And indeed, the European Court of Human Rights, the Court of Justice of the European Union support us, guiding us in looking for the best solutions on how to implement European shared values. Today at the conference, underscoring the role of constitutional courts in specifying the shared united European values, it's important for us to understand that the contribution of the constitutional courts is being highlighted as very important for functioning of a democratic state governed by the rule of law. For us, it is the Constitutional Court, but also the European Court of Human Rights and the Court of Justice of the EU are very important in providing interpretation of legal provisions which are generally binding. And these are binding to everyone, members of society, businesses, and also institutions of the state and municipalities. And our constitutional court is harmonizing constitutional provisions and international law and has indeed promoted merging of international and national law and has never attempted to create a dual system in Latvia. The Constitutional Court of Latvia has been very effective in ensuring united understanding of European values and also protecting these rights. That is why today, in the current situation, where the war is being waged very close to Latvia, I would like to underscore that in conditions of war and hybrid threat, the role of national courts and international courts is essential, and sometimes it can be decisive. Constitution is a living instrument. We all, as lawyers, know that, and that's why judges and the judges have the role and the task to use this tool in a dynamic way, going forward along with the times and responding to events in society without diminishing the value of and importance of European shared values. The courts, the European Court of Human Rights and the Court of Justice, when adjudicating cases, always take into consideration the situation of the specific state, its historic and actual context. But even more, each national court as well has had to respond adequately to events in the states. And thus, our Constitutional Court has indeed set a very high standard here in Latvia. For example, in examining facts of the case in the context of the current situation. And here we can speak about a recent judgment in the case number 2023-040106 regarding testing the proficiency of the Latvian language of those Russian citizens who have been granted residence permits. And here the court has underscored that the task of guaranteeing the national security is of utmost importance. And the court has examined the current situation, the historical context, and the Russian Federation, which has been recognized as a state supporting terrorism, is still involved in aggressive military and hybrid activities against independent countries. And the persons who maintain ties of loyalty with such state pose risks to our security, although we are not direct victims of a military conflict. At the time when the foundation of European values are being threatened by the bloody war waged by the Kremlin close to our borders, we have to remind ourselves of our shared European fundamental values. We all stand for freedom, democracy, including militant democracy, human rights, and the rule of law as our shared values. We can be united in Europe. And thanks to the contribution of each constitutional court, because our courts are guarding the rule of law and are embodying this awareness within the national legal system. I wish to all of us to find answers today to questions which have not been answered yet, to identify challenges for the future and look for solutions to increase the role of constitutional courts in reinforcing our shared values and preventing any threats. Madam Minister, thank you for this very inspiring address, and also the very high appreciation of the Constitutional Court of Latvia, and for also thank you for the well wishes for our conference.
That's why, logically, I kindly ask panelists for the first session, my esteemed colleagues, Martin Kaujer, Peter Huber, and where is my Ukrainian colleague? Yeah, Mykola Gnatovsky, to take a seat for panelists, and we could start to share our views on constitutional identity issues. So, I am honored to be chairperson for the first panel. And in a few words, I just explain why in this year Latvian Constitutional Court has chosen a topic about constitutional identity. Well, we know quite perfect that Article 2 of Treaty on European Union is quite explicit about postulating that the European Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. The source of these shared values is not some outside dictate. Rather, these values, of course, are common to the member states. So that's why, on the one hand, this could lead to the conclusion that conflict between shared European values and national constitutional identity could not be real. But on the other hand, it is clear that the understanding of the scope, content, impact, and possible development of the shared European values and the concept of national constitutional identity is not uniform among all involved actors. These aspects, to some extent, explain, in my view, why time by time the Court of Justice of European Union deals with the issues related to national constitutional identity. And more frequently, a concern is raised in public statements and academic literature about what has been called an abuse of the concept of constitutional identity. Taking into account above-mentioned observation, in my opinion, it is necessary to discuss the concept of national constitutional identity. It is a sensitive one, but it does exist in our legal order. We need unified understanding of what is true constitutional identity and how it respected in the context of shared European values. European Union is not a federal country. It is a union of independent countries with its own culture and tradition. And this is, in my view, beauty and the strength of European Union. But these diversities should not be used as a tool to split Europe. These diversities must be discussed in order to reach unified understanding of this concept. This could lead to the outcome that the concept of national constitutional identity would serve as a tool to unite and make Europe even stronger. And united and strong Europe is utmost important nowadays when we live in so turbulent time. So that's why Constitutional Court of Latvia proposed to engage in dialogue with all the involved actors in order to approach a universal understanding concerning factors that impact the shared European values. And in this regard, we have invited 3 distinguished speakers to discuss these issues. And as a first speaker, I would like to take the floor my dear colleague, esteemed colleague, Martin Kujer. Martin Kujer is Vice President of the Venice Commission, Justice of the Supreme Court of the Netherlands. Previously, he worked as a professor of human rights law at Vrije University of Amsterdam for 15 years. And what is really interesting, that he received his PhD on his promotion work, The Blindfold of Lady Justice. So romantic. Martin, please take the floor.
Good morning, ladies and gentlemen. It is a true pleasure being back here in Riga, and my sincere thanks to the organizers of this conference for their kind invitation. I'm honored to attend this conference hosted by my good friend and colleague in the Venice Commission, Aldis. And it is equally good to see so many other dear old friends, and I'm looking forward to making new friends over the coming few days. Ladies and gentlemen, I wear, even though you can't see it, 2 hats today. I represent the Supreme Court of the Netherlands, together with my dear colleague Matthias Borgers in the audience, expressing our gratitude for the bilateral relations our 2 courts have, and I represent the Venice Commission. When Aldis invited me to attend this conference, he did so in Venice, while referring to the particularities of the Netherlands legal order. So I will try to address both perspectives and that's the main challenge, do so within 20 minutes, because otherwise my dear friend Aldis will become less friendly with me. But allow me to first make a few introductory remarks. Let me say, and that is very much in line with what you just said, Aldis, at the outset, that in most, if not nearly all cases, the constitutional domain of the member states mirrors the shared European values as laid down in various Council of Europe instruments like the European Convention on Human Rights and in EU law, as these international instruments are firmly based upon the constitutional traditions common to the member states. If we are discussing the need to reconcile constitutional identities with European values, it is good to stress at the outset that we are talking about the rather exceptional situation that both domains do not coincide. My second preliminary thought when preparing the speech was that a possible or perceived tension between the constitutional particularities of a given legal order and the European domain is not necessarily a purely judicial or even legal matter. The issues we discuss also relate to the more general relationship between the judicial domain, including the Constitutional Court, and the political domain, setting the standards which are to be applied by the judicial domain. I think it is fair to say that the constitutional identity of a given state is a fairly static concept, which is unlikely to be subject to many changes. But making changes is, ordinarily speaking, not impossible. The national legal order, even the constitutional dimension of that legal order, is in the end subject to political developments. And to a certain extent, that is less true for the European Convention on Human Rights and other intergovernmental instruments. Once an international standard has come into existence, its application and interpretation are almost exclusively in the judicial domain. It will be near to impossible for the Committee of Ministers of the Council of Europe, for example, to interact with the judicial domain on the interpretation of those European values. Looking at the debate about the perceived clash between national particularities and the European legal order in some European countries in recent years, two common features are noticeable. One, it is mainly a controversy in the political domain about judges too easily overturning decisions taken by democratically elected representatives in Parliament. And two, the controversies usually do not concern constitutional issues, but rather policy areas such as immigration law and criminal justice. My third and final preliminary comment is this. Obviously, it makes a huge difference whether we are discussing the European values within the framework of the EU legal order or the European values within the intergovernmental setting of the Council of Europe. The need to reconcile constitutional particularities with European standards will likely be less pressing in the context of the latter, in which minimum standards are laid down and the margin of appreciation left to contracting states is often emphasized. Admittedly, the EU legal order is fundamentally different in that respect. It sets the standard. The European Union recognizes the existence of certain essential characteristics of the member state, for example, Article 4 of the Treaty on the European Union. But if a matter is regulated by EU law, then it takes precedence over any provision of national law, including constitutions. Ladies and gentlemen, let me turn to the Venice Commission. It has always held that each country should find its own solution in line with its own constitutional, legal, and cultural traditions. The Venice Commission supports and promotes diversity, but such diversity may not become a pretext for not meeting binding international standards. The Venice Commission identifies the red lines, but within those red lines, each country is free to choose how to reach the goal of meeting international standards, provided that it reaches it and does not overstep the red lines. It reminds me of an anecdote once told by a former judge of the European Court of Human Rights, who characterized the cooperation between the European Court and national courts as follows. She described the national courts as the drivers of a car and the European Court as the car's navigation system. The driver enters the intended final destination and receives instructions about the route to take. I see some of you know the anecdote. Here it is better to keep to the left. Here I would turn to the right. And the navigation system ordinarily does not comment on the desirability of your final destination, i.e. the policy goal, but does provide instructions on how to get there, the legal tenability. Sometimes, as a driver, you know a better route because you are familiar with the terrain. Then you sometimes are a bit stubborn, deviate from the instructions. That does not necessarily lead to accidents. Sometimes the navigation system even adjusts the suggested route. But very occasionally you will be told by the navigation system, turn around, return to the route. Assuming, and I admit this is an essential precondition, that the driver does not want to total the car, you take such indications seriously. Not because you must, as judgments of the court are legally binding, but because it is better for you in the end. A similar approach can be identified in the work of the Venice Commission. Let me mention two fairly recent examples, Hungary and Lebanon. In 2021, the Commission was asked to give its opinion on constitutional amendments to the fundamental law of Hungary. One of the amendments concerned education and upbringing of children. The constitutional legislator referred to the Hungarian constitutional identity and stipulated that Hungary shall ensure an upbringing that is in accordance with the values, and now I quote, based on the constitutional identity and Christian culture of our country. The Venice Commission in its report did not raise any problem with the constitutional amendment as such, but it did stress that the state must ensure an objective and pluralist curriculum and avoid indoctrination in public education. Whether application of the constitutional provision would be in conformity with international human rights standards would depend on how the provision would be interpreted. The Commission signaled a risk that the right to education, as well as the freedom of religion and belief and the principle of non-discrimination, could be violated if the state were to use public education for ideological goals, to favor the most influential philosophy of life. For instance, by promoting in education specific values of the Hungarian constitutional identity and Christian culture. It's an issue, by the way, that's constantly on the agenda of the Venice Commission. It will be on the agenda for the plenary in March as well. I can't comment, of course, on the new Hungarian opinion, but I think it is good to stress at this time that there is a difference, of course, in our discussions between constitutional identity and a claim for national sovereignty. Those are two very distinct issues. Similarly, constitutional identity played a role in an opinion in respect of Lebanon in 2022. The political system of Lebanon is characterized by power sharing between three main religious communities, Sunni Muslim, Shia Muslim, and Christians. The confessional principle follows from the Constitution of Lebanon, which provides for the parity between representatives of the Christian and Muslim communities in parliament and for the proportional representation of confessions in government. But in reality, the confessional principle also applies to the judiciary, as many posts in the judiciary have a confessional label. For the Venice Commission, there is a certain tension between the confessional principle and the principle of merit-based appointments in the judiciary. It therefore recommended that any legislative reform of the judiciary should aim at introducing such mechanisms that help a change of direction from the continued application of the confessional principle in practice towards a system of appointments which is essentially based on the merits of a candidate. However, the Venice Commission continued by underscoring its understanding that, and I quote, the total abandonment of the confessional principle in the milieu of the Lebanese social and political construct may be a matter of a more distant future. In sum, the Venice Commission has consistently held that it is only for a constitutional court to interpret the Constitution. Judgments of constitutional courts have a final and binding character, and they have to be respected by all public bodies and individuals. And the Commission demonstrates a great deal of respect for constitutional particularities, but it will always draw attention to the red lines. The manner in which it will do so depends on the nature of the international standard at stake. A temporal and gradual approach may be a solution, as in the case of Lebanon, or stressing the responsibility of the legislator to interpret and apply provision of constitutional identity in a manner consistent with the state's international obligations, as in the case of Hungary. And one may argue, in my opinion, that a similar responsibility rests on the shoulders of constitutional courts, i.e. the duty to choose as much as possible a treaty-compliant interpretation of a constitutional provision. Ladies and gentlemen, that brings me to the third and final part of my presentation. How do we deal with such tensions in the Netherlands? First of all, in my personal view, the dilemma is less prominent in the Dutch debate. That may be due to the combined effect of A, less outspoken constitutional identity in the Dutch constitution in comparison to some other European constitutions, and B, a traditionally strong reliance on international law. The Netherlands has a rather uncommon system. On the one hand, Article 120 of the Dutch Constitution prohibits a judge checking the constitutionality of acts of Parliament, in line with the doctrine of supremacy of Parliament. However, at the same time, Articles 93 and 94 of our Constitution provide for direct applicability of international legal norms, and moreover, these norms have a higher standing than domestic legal norms, including our own Constitution. So, human rights standards play a vital role in the Netherlands' domestic legal order and the constitutional debate. A human rights-related debate in the Netherlands will likely focus on international human rights treaties. This model has resulted in a rather dormant existence of our Constitution. The constitutional debate in the Netherlands is not as vivid as in various other countries. Most policymakers and indeed legal practitioners fail to see the added value of keeping our Constitution up to date in light of the fact that the judiciary offers a high level of legal protection applying those international standards. Perhaps one should say pragmatism is part of the Dutch constitutional identity. Having said that, over the last few years we have seen a renewed interest in our Constitution, such as the inclusion in 2022 of a general provision stating that, and I quote, "The Constitution guarantees fundamental rights and democracy based on the rule of law." So the constitutional legislator should, in case of further amendments to the Constitution, assess whether these amendments respect rule of law requirements. It is difficult to identify a particular explanation for this renewed interest. Most probably a combination of factors. The fact that there has been rule of law backsliding in some countries has led to a debate in the Netherlands how well our system would be protected against such developments. The fact that the Dutch legal order was recently confronted with major shortcomings related to the Child Care Allowance Act, in which the primary reliance on international standards proved to be insufficient because there are areas where the European Convention on Human Rights and other human rights conventions do not provide remedies. But perhaps it is also due to the fact that some political forces in the Dutch political landscape advocate that the Netherlands should withdraw from the convention system, which led many to the conclusion that such a passive attitude towards our own Constitution is no longer desirable. Fact is that many issues which would be considered as a constitutional issue as in other countries are solved in the Netherlands via international standards. In any case, a constitutional jurisdiction, like the Supreme Court in the Netherlands, plays an essential role in translating the international acquis for the benefit of the national legal order. Such a translation can sometimes be very difficult. It's not always easy to ensure that the international standards fit into the national legal culture. But in my experience, it is rarely a head-on collision. It just takes careful navigation. In a more general sense, for me, that's the role of the highest courts in a national legal order. They are, as it were, Google Translate. They try to translate the not always easily understandable European acquis into the national legal order, while providing guidelines to the other stakeholders in the national legal order on how that international standard should be translated into everyday practice. And at the same time, they try to convey messages to the European courts as to the complications that national courts encounter in the loyal application of that European acquis. And in this way, they are the hinge in that layered legal order. The manner in which the Supreme Court will do this mirrors the approach taken by the Venice Commission. In most cases, a solution may be found by choosing a treaty-compliant interpretation of a given domestic provision. Sometimes, the Supreme Court opts for a temporal solution. Let me briefly give you one example. Dutch criminal law allows the judge to impose a life sentence. And unlike other jurisdictions, that really means for life. As you are well aware, there's case law of the European Court of Human Rights in this regard. In 2016, the Dutch Supreme Court dealt with a case in which the Court of Appeal had imposed a life sentence. It noticed that, contrary to European case law, Dutch law at the time did not provide for a possibility to review the life sentence after it had been imposed. If the law would introduce such a review mechanism, Dutch law would no longer be incompatible with the requirements of Article 3 of the Convention. But introducing such a mechanism was not for the judiciary, but for the legislator. The Supreme Court decided to adjourn the case for 14 months in order to enable the government and political decision makers to make the necessary adjustments. And this is what happened. Subsequently, the Supreme Court held that the imposition of a life sentence would no longer be considered incompatible with Convention standards. But it also warned the authorities, if future cases would demonstrate that despite the new review mechanism, life sentences de facto were never reduced, the Supreme Court might reconsider its position as regards the imposition of life sentences. For me, the example demonstrates how a constitutional jurisdiction may play its role. Carefully examining what exactly the international standard requires, identifying how to best fit that into the domestic legal order, while respecting the constitutional relations between the various institutional actors. Mr. President, I conclude. My last message would be a simple one. Dealing effectively with apparent tensions is, in my view, not something which can be solely solved within an institutional context. All too often, interpersonal relationships are equally, if not more, important to finding a solution. And also for that reason, conferences like this are valuable. Meeting with your colleagues, talking about issues of common concern. And that is why, also on behalf of my colleagues in The Hague, I thank Aldis and his constitutional court for the bilateral ties with the Dutch Supreme Court, which we value immensely. Ladies and gentlemen, I thank you very much for your attention.
So, dear Martin, thank you very much for your comprehensive insight and giving for us this insight from the perspective of two hats, and what you as well said at the end of your presentation, some sort of key sentence how to solve possible conflicts between shared values and some elements which could be treated as a national constitutional identity. Dear colleagues, let's proceed with our program, and now it's time to invite a second speaker. And second speaker is esteemed colleague Mykola Gnatowski, Judge of the European Court of Human Rights. Mykola Gnatowski has been a member in various international organizations and bodies, including International Expert Board on Crimes Committed During Armed Conflicts at the Office of the Prosecutor General of Ukraine. Dear colleague, actually, when we worked on our program, we decided to invite colleagues from the European Court of Human Rights to speak about concept, national constitutional identity, which is more inherent to European Union law. And actually we thought how it would be, how a person would feel, because maybe this field of law is not so comfortable for you as a convention system. But I use this momentum to express my gratitude for being brave and said, well, it's for you quite a good challenge, and you are ready to share your knowledge and your insight how national constitutional identity looks from your perspective, from your experience and your knowledge. So, dear colleague, Mikola, I would like to take the floor.
Thank you very much indeed, Mr. President. Dear President Lavinch, dear Minister Libinia Egneve, dear Advocate General, dear judges, dear colleagues, ladies and gentlemen, I am absolutely delighted to stand here in front of you in this magnificent room today. And I'm very grateful to the Constitutional Court of Latvia for the opportunity to return to Riga and to participate in this important discussion. And I would also, of course, take the opportunity to thank the very impressive organizing team of the conference for their impeccable work, for gathering us all here today. Well, indeed, the topic of constitutional identities, as you mentioned, Mr. President, is high on agenda, of course, for the specialists in the European Union law, but also in European constitutional jurisdictions. The Court of Justice of the European Union for quite a long time. But certainly there is an aspect there which is very relevant to the work of the European Court of Human Rights. And there's certainly an internal discussion within the European Court of Human Rights lasting for actually quite many years already, but being continued up to the very, very recent moment, and I'm sure this is by far not the end, about the meaning of constitutional identities. Now, I also follow the discussions that have taken place in the dialogue between judges at various levels, and I would particularly like to refer to the conference that took place here in Riga in September last year, which was organized under the Latvian chairmanship of the Committee of Ministers of the Council of Europe on the role of the judiciary and in the execution of judgments of the European Court of Human Rights. I read its materials and I even watched parts of it on YouTube, because I think that's a fascinating discussion, and I am sure that today we will be able to continue this exchange. And I'm very happy to be able to express my personal views on the subject, even though, of course, they would inevitably be views of somebody who is currently exercising the function of a Strasbourg judge. And I will also say that many of what I'm going to say would resonate very much with what Martin has just set out in his presentation. I think that on the issues of principle we are exactly on the same page. Now, indeed, it's true that the application of the concept of constitutional identities, if any, at the level of the European Court of Human Rights, its relevance to the correct application of the European Convention on Human Rights is not a very straightforward issue. So I will not be able to provide a definitive response today. However, I will try to address this concept first and foremost in the light of international legal obligations of states under the European Convention on Human Rights. And I will then discuss some of the instances where the Strasbourg court has had an opportunity to engage with this concept, to understand the relevance of the concept for the case law of the court. Now, the description of this panel and the very important points that we have in the program of this conference, well, it posits that there may be situations where there appears to be a conflict between a constitutional identity and a European value. And that one of our tasks today, as you, Mr. President, said, is exactly to discuss how such conflicts could be resolved. Well, I do not disagree that there may occasionally be an appearance of such a conflict. However, I have an obvious difficulty with this whole proposition because the concepts at stake are rather vague in my view. The concept of constitutional identity, even though it has already been applied for quite some time, is not necessarily so clear, at least from, I would say, the Strasbourg perspective. And the concept of European value is not very clear either. So, of course, the more vague it is, the higher the chances that some people would see conflicts, whereas others would simply deny the very existence and the very possibility of such conflicts, well, essentially with equal authority. And of course, my instinct here would be to engage in a purely legal analysis, if that is possible at all. But nevertheless, this is the frame of mind with which I come here, and I would insist first and foremost that the notion of European values then can best be understood from the perspective of the European Convention on Human Rights. The preamble to the Convention clearly explains its background, its object, and its purpose. The Convention is a binding international instrument, creating a unique system of collective enforcement of human rights by like-minded European countries who, I quote, have a common heritage of political traditions, ideals, freedom, and the rule of law. And this common heritage is an indispensable basis for the constitutional identities of European states. This is what defines their Europeanness, so to say. This also means that the constitutional identities of European countries should best be seen as already including human rights and fundamental freedoms protected by the European Convention on Human Rights. In one of the most recent judgments of issued by the Grand Chamber of the European Court of Human Rights, Humpert and others versus Germany, the court decided to clearly, albeit succinctly, outline its role. And there is a section in the judgment which is actually named the role of the court. I think it's a very important one. There's 4 points there. First, the high contracting parties to the convention have undertaken to secure everyone within their jurisdiction the rights and freedoms defined in Section 1 of the convention. This is Article 1, as you know. It is the duty of the court to ensure the observance of the engagements undertaken by the contracting states, Article 19 of the convention. According to Article 32 of the Convention, the Court provides the final authoritative interpretation of the rights and freedoms defined in the Convention. Second, the Court's rulings serve not only to decide those cases brought before it, but more generally to elucidate, safeguard, and develop the rules instituted by the Convention, thereby contributing to the observance by the states of the engagements undertaken by them as contracting parties. Third, contracting parties should abide by the rule of law standards and respect their obligations under international law, including those voluntarily undertaken when they ratified the convention. The principle that states must abide by their international obligations has, of course, long been entrenched in international law. In particular, and I quote, "A state cannot adduce as against other state, its own constitution with a view to evading obligations incumbent upon it under international law or treaties in force." This is a quotation from the advisory opinion of the Permanent Court of International Justice in a very old, of course, case on treatment of Polish nationals and other persons of Polish origin or speech in the Danzig territory. Further, under the Vienna Convention on the Law of Treaties, a state cannot invoke its domestic law, including the Constitution, as justification for its failure to respect its international law commitments, Article 27 of the Vienna Convention on the Law of Treaties. And the fourth point, it follows from the aforementioned principle of international law, as well as inter alia from Articles 1, 1932 and 46 of the Convention, that the contracting parties must fulfill the obligations voluntarily undertaken by them when they ratified the Convention. As the Court does not engage in matters of domestic constitutional interpretation, it is for the contracting parties to choose the manner in which they fulfill their obligations under the Convention. From this perspective, constitutional identities as such should not and cannot be seen as a way to justify a failure by any party to the Convention to comply with its provisions or with a final judgment of the European Court of Human Rights. In other words, directly juxtaposing European values and constitutional identity would simply not be permissible under international law and in the system of the European Convention on Human Rights. As many of you would certainly recall, at last September's conference in Riga, the Court's President, Shifra O'Leary, in her speech insisted that it is only in exceptional circumstances that the Court can accept constitutional heritage or identity to accommodate it in the margin of appreciation accorded to states as a legitimate ground for a finding of no violation in situations which would otherwise be problematic under the Convention. She added further that the very concept of constitutional identity must be subject to a narrow interpretation associated with the fundamental structures, political and constitutional, of the state. Otherwise, we may find ourselves on a very slippery slope in a convention system serving 46 quite heterogeneous states, each with their own history and imprint of the latter has left. Well, one certainly agrees with such a view. Putting forward the argument of constitutional identity to defend otherwise impermissible conduct under the European Convention on Human Rights could, in the end, defy the very object and purpose of the Convention. At the same time, I personally think that this discussion doesn't simply stop there. Instead of relying on the vague ground of constitutional identity, it is incumbent on the European Court of Human Rights to look deeper into what is the concrete reason for the state's interference with a certain right or freedom. In other words, the court must understand and must define which part of the so-called identity is at stake, what it means, and how it came about. Only through this, and not simply by invoking the magic formula of constitutional identity, the court can accurately assess whether the state has overstepped its margin of appreciation. Turning to the case law of the court, I cannot fail to note that the concept of constitutional identity is very commonly associated by commentators with the 2022 judgment of no violation in the case of Savitskis and others versus Latvia, the Grand Chamber. However, arguments that could have been at the relevant time presented as relating to constitutional identity of the state concerned are present in many other important judgments that the court adopted long before the Savitskis case without explicitly invoking the concept of constitutional identity. Let me give you two extremely well-known examples of cases decided by the Grand Chamber. In fact, in both cases, the result was the no violation, adopted by a very large majority, 15 votes to 2 in both cases. In 2011, in Lauzzi and others versus Italy, the Grand Chamber overturned the Chamber's judgment and concluded that the presence of crucifixes in state school classrooms did not violate the right to education enshrined in Article 2 of Protocol 1 to the Convention. In coming to this conclusion, the Grand Chamber took the view that the decision whether or not to perpetuate a tradition falls in principle within the margin of appreciation of the respondent state. And under the circumstances, the rights of parents to ensure that the education of their children and the teaching was in conformity with their own religious and philosophical convictions was not violated. In 2017, another extremely famous judgment, the Grand Chamber adopted the judgment in the case of SAS versus France. which concerned the ban of wearing religious face covering in public, introduced in France by the legislator in 2010. By prohibiting everyone from wearing clothing designed to conceal the face in public places, the respondent state had, of course, to a certain extent restricted the reach of pluralism, since the ban prevented certain women from expressing their personality and their beliefs in wearing the full face veil in public. However, the court essentially agreed with the government that it was a question of responding to a practice that the state deemed incompatible in the French society with the ground rules of social communication and more broadly the requirements of living together. From that perspective, the responding state was seeking to protect a principle of interaction between individuals, which in its view was essential for the expression not only of pluralism, but also of tolerance and broad-mindedness, without which there was no democratic society. It could thus be said that the question of whether or not it should be permitted to wear the full face veil in public places constituted a choice of society. And then the Grand Chamber examined exactly how the legislator went there and decided that the convention was not violated. Having read the judgments in Laozi and in SAS, one could say that the tradition of keeping the crucifixes in Italian classrooms or banning full-face veils in public in France was part of the constitutional identity of those states. However, resorting to such an argument would not have strengthened the judgments of the Grand Chamber. Quite to the contrary, I think it would blur the analysis of the core of the issue, which was provided by the Grand Chamber in each of these judgments. Of course, the Grand Chamber didn't hide it behind a fairly vague concept of identity. So it went directly to the heart of the matter. Now, very recently, a similar approach was chosen by the court in the case I have already referred to, Humpert and others versus Germany, in which the Grand Chamber, by 16 votes to 1, found no violation with respect to disciplinary sanctions on teachers with civil servant status for participating during their working hours in strikes organized by their trade union, in breach of the constitutional ban on civil servants striking. While the ban on strikes for public servants is inextricably linked with the constitutional regulation of public service in Germany and could in principle be considered as the part of the country's constitutional identity, the court chose not to engage with this argument. So the absence, I would say, of the concept of constitutional identity in the judgment speaks actually more than otherwise the court engaging in discussion of this notion. Instead, the Grand Chamber carried out a careful analysis of the specific circumstances of the case and found that the impugned measure did not render trade union freedom of civil servants devoid of substance and reflected a proper balancing and weighing up of different potentially competing interests. Therefore, the margin of appreciation was not exceeded. Let me return to the cases against Latvia, starting with the Savitskis, the judgment in which the constitutional identity, as explained by the Constitutional Court of Latvia, plays an important role and has been hotly debated inside the court, which is evident, of course, by a very strongly worded joint dissenting opinion of 3 judges, O'Leary, Groziev, and Lemons. And, of course, outside of the court, including by academic commentators. Here I find myself in a curious, but I must confess, not uncomfortable position, where I actually share the key points made by the dissenters, but I fully agree with the judgment. Because, as I made already clear, I hope, I'm not supportive of invoking the concept of constitutional identity to justify violation of convention rights. However, Savitskis is precisely the case where the notion of identity is appropriate, but the meaning is rather different. And here, in my view, we are dealing not so much with constitutional identity or even national identity in the sense of Article 4 on the Treaty of the European Union, but rather with issues emanating from the international legal identity of a state that has been a victim of foreign aggression and long-lasting occupation. To give correct answers to various human rights challenges Latvia and several other states in an analogous situation have faced since the restoration of their independence, the European Court of Human Rights, being an international judicial institution, must engage in a fully fledged international legal analysis of the context, such as the transfer of population by the occupying power. It is this background that should, in my view, be included in assessing the compliance of the solutions found by the state concerned with the Convention and with the Court's own case law. And here I also would like to refer to the very powerful separate opinion of Judge Ziemele in an earlier case of Andreeva versus Latvia. It's also quite curious that legal commentators said that the more recent chamber judgments in the so-called linguistic cases, Valiulina and others versus Latvia and Djibouti and others versus Latvia, were based on the constitutional identity, and this is simply not true, because there was only one comment in Valiulina in passing on the constitutional identity, basically where the court said that the Constitutional Court of Latvia analyzed the question, and the analysis made it clear that their assessment was not arbitrary. And that's it. Otherwise, the court quite simply applied its previous jurisprudence starting from the Belgian linguistic case. So these are basically not cases about constitutional identity as such. I assume that my conclusion is quite clear. From the perspective of the European Court of Human Rights, it is essential to look into the concrete issues and interests at stake in assessing whether the state has overstepped or not its margin of appreciation, and when necessary, not to hesitate to fully engage with the relevant international legal law context, rather than to apply the notion of constitutional identities as an umbrella term justifying deviations from the rights enshrined in the Convention. And it seems to me that this is the approach so far taken by the Strasbourg Court. I very much look forward to the continuation of this discussion. I thank you so much for your kind attention, and once again, many thanks for the invitation. Thank you.
Thank you, dear colleague Mikola Gnatowski, for so many valuable examples you mentioned, how in which those two-way concepts, as you put it at the beginning of your speech, both shared European values on the one hand, and on the other hand, national constitutional identity concept, both are vague, and it is quite uneasy to be confused if we should operate with a vague concept. We could come to different outcomes. Right one, wrong one, but as you already gave a key, how to find right answer is that court, any court, constitutional, national constitutional court, court of general jurisdiction, has to bear in mind that particular state, and courts represents, of course, certain state, has undertaken obligations to be always in line or to comply with the requirements of convention. That is an answer how to not to be confused operating with two vague concepts. Well, dear colleagues, let's move forward. Let's move forward, and now it's great honor to invite to speak in this conference Peter Michael Huber, professor of the Faculty of Law at the Ludwig Maximilians University in Munich. He is well-known public and constitutional law scientist, and we Constitutional Court judges at Latvian court, we had a great opportunity to meet you a couple of times in Riga, in a short visitings, just to discuss those interesting issues what we had at the court. That was a great idea of President Ineta Ziemele, and we really appreciated your openness and friendly attitude to our court. So, dear colleague, I invite you to take a floor, but now this topic is about constitutional identity.
Mr. President, dear Aldis, thank you for inviting me again to Riga. I always like to be here, and I think it's the 8th or 9th time I've come to your beautiful city, and I'm most grateful to the Constitutional Court of Latvia that you continue on reflecting on constitutional identities. There may be some among us who think that it isn't worth time because they in Luxembourg or in Strasbourg don't listen anyway, and it's rather detrimental to their approach of imposing their solutions on member states' courts and judicial systems. But I think in the long run, there's no alternative than listening to each other, than learning from each other, and even correcting one's position after having learned something. This doesn't apply only for national constitutional courts, such as the Bundesverfassungsgericht, with which I was a member until last year for 12 years, but it also applies to the friends in Luxembourg or in Strasbourg and in Riga and other courts. Having said this, I want to quote the minister who said that the European Union hasn't come over us like somebody who occupied our countries, but we went there voluntarily. You 20 years ago, we 70 years ago, but it was always on the basis of freely adopted treaties applied and approved by parliamentary laws, which leads me to a slight contradiction, Aldis, to you and to my esteemed Dutch colleague. I think most member states have the approach that union law isn't applied in the countries because there is some strange or external power that is imposing it, but it is within and on the basis of the limits of the respective constitutions and the limits also constitutions put to European integration. The German basic law is quite clear, which says we should participate in the European Union. We do everything the European Union to fulfill its objectives, but there are limits, the limits of, we call it our eternity clause, and it has been reframed, renamed the constitutional identity of the basic law. It's expressly said in our constitution that Article 79, paragraph 3, that this is also a definite limit to European integration as for the constitutional amending legislator. And this means that the stipulation of an unlimited primacy, in Karlsruhe we translated primacy as precedence of application, because this doesn't entail the hierarchical perception that primacy has. Primacy is applied in Germany between the federation and the states, which is a federal state. Precedence of application means that in the specific case, the union law prevails. This is something different, but this is just words, but Hegel knows that words, already said that words count, and what you can't put into terms doesn't exist. Against this backdrop, I think there should be no need in reconciling constitutional identities and European shared values, as the European Union is a creation of the high contracting parties. And the high contracting parties share the common values laid down in Article 2 of the Treaty of the European Union. It is evident that we all stick to the rule of law, human dignity, democracy, and the social welfare and the other values that are laid down there. We have realized this in a case I prepared 3 years ago. I've quoted it in my paper. In German we call it Ökotox-Daten, Ecotox data. It was on the concession of a veterinary device in Germany, which had already been conceded in Britain at that time, and the German administration made some mistake. And the question was, under which measures, under which standards shall these mistakes be judged? According to the European Charter of Human Rights or according to the basic law? In the one case, it would have been Article 16 of the Charter of Fundamental Rights. On the other case, Article 12 of our basic law, freedom of profession. And we found out that no matter which norm we apply, the outcome would have always been the same. There is, in both legal systems, in both value-based systems, human dignity, going back to the Charter of the United Nations from 1946. There is a link between human dignity and fundamental rights, or at least freedoms and equality. There's a similar structure as far as the scope of protection, infringements, proportionality is concerned. There is a core guarantee, which in German we call Wesentlichkeitsgarantie. So, putting it under an abstract and academic point of view, you find out that the common values, as far as basic rights are concerned in this case, but the same applies for the general values as rule of law and democracy, should be more or less the same. Perhaps not in the individual case. I think what we must always keep in mind is that there is a certain scope of concretization, I would call it. Not scope, margin of appreciation, but a scope of concretization, because our 27 states are quite different, and some are monarchies and others have the republican form of government, which is in France or Italy, for example, part of the national constitutional identity, Article 89, paragraph 5, I think, of the French Constitution, and similar applies to the Italian one. In Germany, we are a federal state. We've made experiences with federalism since the 13th century, and perhaps therefore we insist a little bit more also on the vertical distribution of power and its observance than other states do, and have a perhaps more sensibility for competences that other legal orders may have. But this is within this scope of concretization. So if there is, from the starting point, not a very big tension and difference between the national identities, I don't speak of abuse. Your case about the ban on strikes, I sat on the bench in this case. We didn't apply Article 79, paragraph 3, because it didn't play a role. And the guarantees for the public service in Germany are laid down in Article 33. They have nothing to do with the constitutional identity. The constitutional amending legislator would be able to abolish public service as it is in the present case. Therefore, it would have been an abuse to go on the constitutional identity in this case. But the problems arise because we are all human beings. And if you put 3 lawyers on a bench, we've got 4 opinions how the case has to be solved. There is never one right solution, unfortunately. There's one authoritative answer to the solution of a case. And this makes things different, because if human beings come into the play, it is obvious that vanities, prestigious thinking, conviction, socialization, bonding, and other things, everything which is arbitrary, it comes, even if we are not aware of it, into the decision. And therefore, it's also obvious that if the same value, let me stick to the example of ecotox data. If the same value as freedom of profession is concretized by the friends in Luxembourg, they might come to a different result than if we concretize the same value, or the Dutch do, or the European Code of Human Rights does. So the question is not have the values to reconcile, but how do we get along with the national and unavoidable tensions that exist from having so many courts? If we had only one court, the Constitutional Court, or only the Constitutional Court in Luxembourg, if I quote Mr. Lennartz, then there wouldn't be any problem. We had one solution, and this would be authoritative. And this leads me to the reflection that we have to put a bigger stress and more attention to the intertwining and the cooperation between the responsible courts, the constitutional courts, the Court of Justice, and the Court of Human Rights. They are theoretically settled by law. But, as you've said, Mrs. Minister, the convention, and the same applies for the treaties, are living instruments. If they are living instruments, they may develop into a completely different way than the founding fathers or the masters of the treaty had in mind. And this will probably lead to tension. And this is also what my court had to deal with as far as Luxembourg was concerned for the last 15 years. The question is the concretization conceived as a living instrument still acceptable or not? How far does it go? And to make a general remark, I would say, if we look at the jurisprudence of the Court of Justice, I have, being a Bavarian, perhaps I'm more sensible than others, I have made the observation that the instruments that have been developed for the single market, precedents of application, the principle of equivalence, Thiel and others, are perfectly developed and imposed. But if you look in the treaties, we find that there are other principles that provide for a variety within the unity, such as the principle of conferral, which, according to my observation, doesn't play a major role. The principle of proportionality, which, according to my observation, doesn't play a real decisive role in the distribution of competences between the Union and the member states. The principle of subsidiarity and others. So I think there is a certain tension in which also the friends in Luxembourg must rethink their line and must perhaps develop further their dogmatics, if you may call it that way, as far as the relationship between the Union legal order and the legal order of the member states is concerned. The solution we decide and you obey is no solution. It must be convincing, it must be coherent, there must be arguments that you do not have to share as a national justice or judge, but which must at least be plausible. And as long as this is not the case, and if this is not the case, we have a certain difficulty. We have made, Inetta and myself, with two other colleagues, the proposal how to reconcile the different thinking. And I say the dumbness also, according to my observation of Luxembourg, something against congresses like we have it here, and the pleas for mutual understanding and learning. One, I think, would be that the Court of Justice has a bigger ear for constitutional courts. My observation is that it prefers to cooperate with ordinary courts. They don't have this political dimension. There's less power play in the midst if they deal with civil or administrative courts. And that cases mostly are more difficult if they come from constitutional courts. I do not want to go back to the cases I've prepared on the European Central Bank. I could talk an hour at least about them, but I think this is a principal issue. And proposal we've made is, why not having the national courts not giving a say to the national courts? According to Article 24, I think, of the Statute of the Court of Justice, this would be possible already now. At least some of the colleagues in Luxembourg share this opinion. But you could also change the treaties and introduce a sort of preliminary request reversed, which in one case, which is still pending at my court, would have made things much easier. Some of you may know the case Egenberger. Egenberger was a case on whether the Protestant church in Germany could require somebody who they wanted to employ would be member of the church. And the employment was meant to prepare a paper for a governmental procedure. And the Court of Justice held that this was not be necessary. They forced, more or less, the Protestant church to employ and to close a contract with Mrs. Egenberger, even if she was no member of the church. Well, church-state relations are a big issue of whether it's constitutional identity. I'm not so sure. The court will decide on that. But they are a very sensible issue in many countries of Europe. In Germany, it has had two constitutional assemblies, for the Weimar Constitution and for the Basic Law, that made a difficult compromise between the autodetermination of the church and the state relationships. And putting that aside, ignoring this, in the case, the German government had argued this is not true what the Federal Court of Labor has said but they didn't care for it and didn't decide it. And then the case went back, and the church made a constitutional complaint to the Bundesverfassungsgericht, which is still pending. I think, had they asked Karlsruhe what the right interpretation of church-state relations is, even in an abstract way, the enlightenment would have been bigger. There are other devices, I think, that could be improved to increase the readiness of the Court of Justice to enter into a dialogue. I think it's detrimental that the terms of 6 years can be renewed once and again, so that people stay in the court for almost 30 years or something like this. In all other courts, like Strasbourg, has been reduced to 9 years. In Karlsruhe, it's 12. If you have someone on the bench for 30 years, he or she gets very powerful. She outwits the rest of the colleagues, and this is not good for the openness of new insights, new ideas, and even new ideas of cooperation. I would have some other suggestions, but we might discuss them on the panel then. Thank you.
Thank you, dear Peter, for bringing to this conference another view on this issue, whether there is necessity to reach some sort of reconciliation between, as we have already mentioned, two-way concepts. Well, you don't see there is such a necessity, but at the same time you stressed that where human beings are involved, then always some problems arises. And that is why we should look to another aspect, how to deal with the tension between two court institutions. And what I noticed during your speech, it seems a very good answer and a key how to deal with that, and listening to each other, learn from each other. And it was so good to hear it, because I know what is the attitude of Latvian Constitutional Court when we face with real or maybe half real conflict between constitutional identity and shared European values. We always try to be engaged in dialogue with the Court of Justice of the European Union. Well, dear colleagues, now we have 1 hour. 1 hour to discuss, and what is the rules? Very simple. Just to push a button, you see on your table some digital equipment, since we live in 21st century, and I will see all information about persons who would like to raise a question, or just to share some point of views, or just reflect on something. And I see there is already a list with 2 persons. And the first one is Konstantin. My dear colleague Konstantin, please switch on microphone, yes, and raise a question.
Can you hear me? Very good. Thank you very much for a wonderful presentation. I understand the challenge of saying my surname, so I don't blame you for that. Very good. Thank you so much for these 4, I would say, excellent presentations. But forgive my ignorance after this fantastic presentation. I still don't understand what constitutional identity is. Basically, if we take this concept seriously and treat it as a legal concept, it has to have some factors that determine its scope. I don't think that this approach, I will know when I see it, would be sufficient in defining a concept of such importance. Right, so what are the factors that can shape the scope of this concept? Is it history? But if we go into history, it might lead us to very negative results. Is it religion, maybe? But isn't the whole idea of constitutional collaboration is to protect minorities, etc., etc.? So, like, what are the factors that effectively determine the scope of constitutional identity? This is my question number 1, and I have a very brief question number 2. And question number 2 is why, and this is mostly for the European Court of Human Rights, why would European Court of Human Rights effectively engage in a conversation about constitutional identity? Isn't it covered by the doctrine of margin of appreciation? So, like, if something is so important for the national member state, it should have been considered within the scope of the margin of appreciation. Thank you very much, and I'm looking forward to your answers.
Konstantin, thanks again for first question. And actually, in case of a little silence when discussion starts, normally there is a little moment of silence, and then someone has to break this ice. And I even prepared a question in order to break the ice, but this was not the case since you already raised your hand. So, but just to add to your first question, dear colleagues, of course, if we operate with vague concepts, this is really useful to understand what does it mean, this concept, constitutional identity. And if I may add to Konstantin's question, I look at Treaty on European Union, Article 4, paragraph 2. Yes, and there is notion national identity. I don't want to be a person who very sticks to the text. No, I'd rather incline to get an idea of legal norms. But anyway, we operate with two different terms, legal terms, national identity and constitutional national identity. Are these terms similar, identical, or there are some differences? This is just a little plus to Konstantin's question. So, dear colleagues, who would take the first initiative? Peter, please.
Well, what the constitutional identity is cannot be decided in Luxembourg on a central level. It is what in German legal thinking you would call a Rechtsgrundverweisung. In Article 4, paragraph 2, it goes back to the national constitutions. In Germany, it's quite easy. We've got a prescription in Article 79, paragraph 3, which says what our constitutional identity is. Nevertheless, also to this application applies what Napoleon has said about constitutions. It's court et obscur, and has to be enlightened in the course of time by the jurisprudence of the Constitutional Court. There have been some highlighting points, such as you may not put somebody into a cell, a prisoner, with less than 3 square meters. You cannot keep him naked there in a room where the toilet is always swapping over. You are not able to extradite somebody to another European state if it doesn't have the right to a fair hearing. We have highlighted, as far as the principle of democracy is concerned, that major expenditures for the federal budget must be approved by Parliament. But there's much more in it. As there's much more in human dignity and in fundamental rights, it's always that way that in the course of time, and with the cases arriving, that that a vague prescription in the Constitution, and all prescriptions in the Constitution are mostly vague, are concretized in a certain way. Therefore, coming to your question, Aldis, we've dealt with the issue in our first preliminary request to the European Court of Justice, what the difference between Article 79, paragraph 3 of the Basic Law and Article 4, paragraph 2 of the treaty is or might be. And our interpretation was that national identity is broader than constitutional identity. The Austrian, for example, they've got as constitutional identity die Baugesetze der Bundesverfassung, Article 44, paragraph 3 of the Austrian Constitution, but to their national identity also applies the fact that nobility is forbidden and that you may not use noble names in Austria. This is not case of the Baugesetze der Bundesverfassung, but applies, as the ECJ has ruled, to the constitution, to the national identity. So my answer, or the answer of our court, was it's a broader area than the hardcore of constitutional identity, even if this remains vague to a certain extent.
Thank you. And Mikola, would you like to reflect on this question?
Yes, thank you very much. Okay, yeah, thanks a lot, Konstantin, for the questions. I will probably try to answer your first question through the second one. Because for the European Court of Human Rights, the whole discussion must be accommodated within the framework of the margin of appreciation. There is no other way, actually, to approach it from the convention standpoint. Otherwise, it would make little sense, in my view. And this is, I think, that has been the methodology so far. So, in essentially the only case where constitutional identity features rather prominently, namely in Savitsky's, that was done exactly through the margin of appreciation. That's how it should be. Now, as regards how to define the concept, I think what we heard now from Professor Huber is exactly the limits for this discussion. For my attitude that I tried to convey also today in my intervention was that, in fact, the European Court of Human Rights does not need the concept, to be quite honest with you, because it can either look into the substance of the issue, and again, margin of appreciation is there. There's, the court is perfectly in a position to say whether a legitimate aim was pursued, whether the impugned measure was proportionate or not. The Strasbourg Court does not require that. There's also a group of cases, and here I think Latvian cases are very much relevant, is where one needs to conduct a fully fledged international law analysis of the situation. And my message also to my own court is that it must not shun, from this necessity. It must not try to pretend as if it were not an international court, because it is an international court. It does have to take into account the international legal concept, and that's why identity is fine there. Again, I cut myself short a little bit, being very mindful of time with the linguistic cases. But in all honesty, again, there is a legitimate interest for the state to preserve and protect its state language. Yes, it is part of the state's identity, well, national identity, I would say, but we don't even need to go there as such, because again, the interest is legitimate, and it is also based on the history and on the international legal background of the situation. So that's how I would take it. Again, I would be very interested in my colleague's view, and also maybe in Martin's view, as to how constitutional identity can be defined. But again, not that I see so much need to do that myself. Thank you.
Martin, would you like to reflect?
Well, would I like to reflect I'm not too sure. I'm not going to thank Konstantin for his question. I think it's a horrible question. I struggled with this when I prepared the speech. I noticed that when I read the literature, by the way, there's a very interesting publication from the Romanian Constitutional Court just a few years ago that collects all kinds of essays also on constitutional identity. Within the Netherlands, it was primarily one academic, Leonard Besseling, who commented on the issue, and I noticed no one gave a definition. For me, but I say this personally, really not as a representative of the Venice Commission, but for me personally, the way I understand it is you have a difference between constitutional provisions and characteristics that are so fundamental to the entire Constitution, underlying all those constitutional provisions, fundamental to that particular constitutional legislator, that could be referred to as the constitutional identity. Usually that means that for that particular reason, constitutional identity becomes a very vague concept. So if it is used, then very often it is used as rule of law, democracy, fundamental rights, but it doesn't become a lot more specific than that. Perhaps, as we have seen in the Hungarian example, a particular religious belief, but I think that is as concrete as it gets. So for me, the more interesting issue is, when is it used, when is it invoked? So not so much what is it, because I think that will remain rather vague, but when is it invoked? And usually it is invoked when there is a dilemma between the perceived constitutional identity and another supranational norm. Then it is invoked. And that is also the reason why it is so closely linked to your second question, I think, because it has a lot to do with deference. When should the European Court defer because of a particular national particularity? And that's why I refer to also the red lines and the margin of appreciation, etc. But that is not so much because what it is, but when is it invoked, the concept. I think there's a distinction between those two.
Thank you. So, dear colleagues, I have a large list of persons who would like to raise a question, even 10 persons. So, just a small tip, how not to be excluded from this list. If you once push a button, keep it. Don't push another one. Don't push another time, because you are out of this list, and if you put for the third time, you are on the end of the list. So, that's why. So now I would like to have a floor Professor George Letsas, and afterward to be in a position of readiness to ask a question, Maciej Špunar. Please.
Thank you.
Yeah, you see. Well done.
Thank you for those really thought-provoking presentations. I have a question for Judge Natowski, whose account, as he just made it clear, and that's how I interpreted him, seems to me to be a very clear account of what identity means, which is that it's redundant. The convention doesn't need it, as you put it. Everything the court has decided in the cases where it's mentioned, the court could have decided without mentioning it. And the way you invoked Lautsi and SAS, where the analysis follows the typical Strasbourg mechanics of, is there a legitimate aim, is interference proportional and necessary in a democratic society? These are the non-mechanics, and that's how the court goes about in every case. You said that's why the court doesn't need it. I worry whether the issue is more serious than that, whether it might be dangerous to use it. Because you yourself said, from the point of view of international law, a state cannot invoke its own domestic provisions to justify violations of the convention, so it could open the door to this kind of argument being made in other occasions, and it's potentially pernicious, its use. And on the issue of the analysis of legitimate aim, it seems to me that even in Savitsky's, you could have the same result by looking at whether, not just the international law situation, but whether there is a legitimate aim there, which plausibly there was, to justify the interference. The worry I see is this: identity is unique. Legitimate aim isn't. If there is a legitimate aim to restrict a right, it would apply to any country for which the aim is present, not just to Latvia, but any country. So it seems to me that it's better to go with legitimate aim, because that ties in with the mechanics of Strasbourg and the idea of universality. Identity will actually, I think, only pave the way for misuses of the doctrine. So if you agree that the court would have decided Savitsky's without mentioning, in the same result, without mentioning the doctrine, is the doctrine of identity pernicious? Thank you.
Yeah, thank you. Thank you very much, Josh. I'll try to be very brief, being mindful of the long list of speakers ahead. So I think your interpretation is of what I said is accurate enough, and I also basically tried to convey the message that there is clear danger in using the concept. Now, in Savitsky's, well, first and foremost, the court should engage with the arguments advanced by the parties. So the court had to respond to the argument made by the Latvian government, and basically following also the domestic jurisprudence. So in that respect, it was unavoidable that the concept comes into light. But it might have been framed differently, because ultimately the result, as I said, I agree with the result, even if I also agree with the principal statement of the dissenters who were unhappy with the use of the constitutional identity. You know, that's okay. There is this danger, not in that particular case, but in abstracto. That's a very valid point, and that's what we all agree on. So I'll just stop there, because I think you said it all. Thank you.
Thank you. And Maciej, please take the floor.
Thank you very much. Let me in the first place thank you, President Lavins, for organizing this conference and for giving us the possibility to discuss, because I've been participating to so many conferences where there was no possibility to exchange the views. So big thanks to you. And as you probably can guess, I would like to refer to the speech of our colleague previously from Karlsruhe, Professor Huber. And I must say in the very beginning that I almost entirely agree with all the remarks. Starting with the question of privacy. We are now in Luxembourg. We are now in Luxembourg pretty convinced that we should not use the terms supremacy, but primacy. Primacy in the case of conflict. So this is an instrument which could be compared to the conflict rule, that if within the scope of application of two norms, national and European, there is a conflict, then the EU norm should be applied. But there is no hierarchy between these norms. You said that we prefer ordinary courts to constitutional courts, and my reply would be the following, that of course, traditionally, our main interlocutors were ordinary courts, because the law of the Union started with the internal market. And it was only recently that supreme jurisdictions, including, in the first place, constitutional courts, started to refer questions to Luxembourg. But I must confess that just relying on my experience, I've been dealing with your case law, with case law of Bundesverfassungsgericht, I think in 10 cases, but in each time there were references made by either Bundesgerichtshof or Bundesverwaltungsgericht, supreme jurisdictions, which in their questions referred to the case law of Federal Constitutional Court. And I think that for the time being, the most suitable remedy it would be to encourage you to refer more questions. And more questions we have from constitutional courts, more the national identity would be represented in our case law. You mentioned the case Eggenberger, very fundamental case. I didn't know that there is now a constitutional complaint pending in Germany, but that for me would be a perfect occasion to refer again the question on certain issues concerning especially this private dimension, horizontal dimension of the Charter. I'm coming from a country where the church is very strong, I would say even too strong. So the issue of autonomy of churches and in general private parties is very close to my heart. And there are examples in which we slightly concretize our case law in the view of references made by Constitutional Court, and Tariko Saga is here the best example. And concerning institutionalization, the length and the possibility of to renew our mandate, that the issue of primary law, and the court of course has no influence on some institutional framework in which we are functioning. But many thanks again for all your remarks. I have and the possibility to have this wonderful discussion. Thank you very much.
Well, I'm not guilty because the two preliminary requests our court has made were drafted by me. So it's up to the others to do so, and we'll see what the colleagues will do. But I'm completely share your opinion. We'll see. Mrs. Messling is here, whether the first Senate will make a preliminary request as far as fundamental rights protection is concerned. But this is part of the communication, expecting that you take us seriously and that you really answer to the question posed. The question of mandate was no reproach, but a personal reproach. But I observe that, as I said, that even deciding cases is a sort of exercising sovereign power. This needs democratic legitimation. And democratic legitimation is not only fulfilled by independence, but must also be bound back to the legal order the judge comes from. And I think there are plenty of devices, such as the lawful judge, which would diminish the role of the president within the court, perhaps abolishing the campaigning for becoming president, vice president, or chamber president, and deciding this by outside. It's not your task, I know that, but I think there could be done quite a lot in framing and embedding the Court of Justice into the European legal space more, that also critics arrive there more directly, as we have to live that in the national courts from day to day.
Thank you. Ineta, take the floor.
Yes, many thanks. And once again, thanks to the Latvian Constitutional Court for this incredible possibility to start celebrating the 20 years of Latvia's and the other 9 member states' membership in the European Union very rapidly, because I will have a chance at the very end of the day to provide dogmatics, as Peter suggested, of the complicated relationship. I will try. But, and also in view of the fact that we have among the colleagues here, our colleagues judges from outside the European Union, and so that they would not get scared of what is going on in the European Union, I should really say that the way we debate the relationship between the three systems, the national, international, represented by Mikola, and European Union, supranational, this is exactly the way we do that. And I think that is the beauty and the strengths of Europe. And you're very welcome as soon as possible to join us in the European Union. Now, very quickly, national identity simply is a matter of life. It is there. And we have, any number of our constitutional jurisdictions have chosen to legalize it in a concept of constitutional identity. Not all, at least among EU member states, but a number. We cannot simply avoid having national identity. Each one of us has it. It's from a sociological, historical, etc. points of view. It's a reality, and law tends to react to it. And I simply leave it at that. Now, then, we have 3 legal systems. Each legal system has historically, again, developed its own concepts, fundamental concepts, the way we react to legal relationships, to politics, or to social relationships. And what we absolutely must avoid is getting into argument with each other by trying to impose, let's say, our concept, be it constitutional law perspective, convention law perspective, or EU law perspective, to impose and somehow, in fact, harmonize, but in a way, indeed, misrepresent what the other system has attempted to do. So here we have to be extremely careful. I will come back to that later on. I've had the privilege to know all 3 of these systems. And so this is why I'm speaking with a certain experience, at least, on these three relationships. Every concept, whether it's margin of appreciation, whether it's national identity in EU law, whether it's constitutional identity, has its purpose and has its role for the purposes of common Europe and for the purposes of building and protecting diversity in unity, because that's what we are representing. So as to that, I think every one of the methodologies already presented so far has its role. The interesting thing right now is what are the synergies? What conclusions do we draw from the synergies? And that's where the dogmatics, the new dogmatics, come in. And I finish with my last point, on the judges and the elections and what have you. Again, as someone in the room who knows all three procedures, available, it is true that in each of the courts that I know by now, the tendency is that the judges that are selected and go into these courts are highly specialized in that particular area, be it the European Convention, so international human rights law, then it is EU law, and then it is the constitutional law. And the reason we have these high specializations, and sometimes they work as barriers, I admit that, but that has to do with the way our legal education still works. And that's the 20th century. So in fact, I would like to throw into, we don't discuss it further, but think about it. What we need in the highest courts are the judges who have also gotten other specializations of the related and the friendly fields. And that's when these difficulties that are real, that's when they will actually go away in a way. And that's a challenge for legal education, interdisciplinarity between the various areas, international law, EU law, national law, etc., public law, private law, because simply the law has evolved in Europe so that it is much more, integrated and the borders are breaking down. I stop here. Thank you.
Ineta, thank you for so valuable reflection on this. And now I kindly ask my colleague Luke, please take the floor. No? Some technical problems?
Red light.
Order.
Red light? Okay, thank you very much for the stimulating introductions and discussions till now. I'm afraid that I belong to the category which Peter Huber described as judges who are too long in a constitutional court, but I can assure that if you are a long time in your court, you are not necessarily followed by your colleagues in your thinking. So, in our jurisprudence till now, we have in two cases of non-admissibility, not excluding that one or another day, the question could raise. But in that respect, I think these two decisions are very similar to the decision of early last month from the Bundesverfassungsgericht on the Elections Act 2018. But suppose that one or another day the question will really arise, what to do? I think I would advise my colleagues, but I'm not sure that they will follow me. So, as you mentioned, then we have to refer, I think, to Article 4 of the Treaty on the European Union. So if my court would doubt if our constitutional identity is respected or not, then we will raise, I think, to the Strasbourg Court a preliminary question on the validity of secondary legislation at stake. And then I think we will expose in our referring judgment why we think there can be a problem. So this seems to me the right way to act, and then I think the Luxembourg court will have all the arguments, and then it's up to the Luxembourg court to decide, has the European Union respected the boundaries of its competence, yes or no? Thank you.
Thank you. Thank you, Luke. Well, let's move forward. Laila Medina. Laila, please take the floor.
Thank you very much. First of all, I also would like to extend my gratitude of being able to be here and talk to the distinguished people here around in the room. And I think being in this room, which is really beautiful and historic, and at the same time enjoying this wonderful technological organization, shows that everything is possible if you really discuss even the history and future can meet together. But going to my topic, actually, I would like more like a question, if possible, to all the panelists. Yesterday, I had the honor to discuss with the representatives of Catholic Church to the European Union and exchange with them the views of what is the relationship between the state and the Church, European Union and the Church. And more specifically, we were discussing the rules of neutrality involved also in the Court of Justice judgments, and also how Article 17 from Treaty of Functioning of the European Union, how it plays its role in the dialogue between the two. And the points we were discussing, and I would like to hear your opinion, what do you think, what could be the international laws or international courts' input into that, how to promote the tolerance and diversity as the common values or as a part of the identity or national identity, but still very different in different member states. In one would be like in France, where tolerance would mean that there is nothing religious in the public area, whereas in Germany or in other countries, that would mean that the church is present and maybe every single religion should be present also in a public place. On one hand, one could argue the first approach is it's more neutral. It aligns everyone to the one understanding of the society, whereas the other one would be more promoting, tolerating that people are different, and they might want to express their being, their identity, also in a visual way or in more active way. But on the other hand, you can discuss that one is more avoiding conflicts, maybe, and the other one is risking that these expressions of religions might provoke also extreme views. So my question would be, what do you see, what is the role of international law, international judiciaries? Which way should be promoted more? Which way should be the platform for those common values? Is it more being as neutral as possible or more promoting diversity?
Well, if I may, my answer would be, as I said in my presentation, that European values entail a scope of concretization. And there are member states that do it more into the way of tolerance and diversity, as you've said, and others do less. Both is legitimate. If you stick to the idea that tolerance and diversity is provided by just applying fundamental rights in a strict way, that fundamental rights are relevant, especially in cases where you find yourself in a minority position against the majority. This is a way of living and concretizing tolerance and diversity, even without giving special rights to minorities, representation, things and others. But in other member states could do it the other way around. What I think cannot be meant by the values is that there's one solution imposed on all of us. And therefore, I must contradict my Belgian friend. As far as our Bundeswahlgesetz was concerned, I think the Senate would have never thought about making a preliminary request to the Court of Justice, because there is, under the principle of conferral, no competence of the European Union to decide on the electoral systems of the member states. And I think it would be also detrimental if a special system to vote, as long as it provides the basic guarantees, would be unified. There's no necessity to do so, and unified in diversity means that there are many flowers on the lawn.
Thank you, Peter. Ilse Puosuma, please.
Yes, hello. Thank you. I am Ilse Puosuma from the Central Bank of Latvia. I also would like to say great many thanks for the organization and of this rich and valuable event. So great many thanks to the Constitutional Court of Latvia and to the esteemed panel for sharing your thoughts. And my question would be to whoever would like to take it, and it regards more another realm, which is, as already the President of the Constitutional Court, when we started discussion, said that since we live in the 21st century, digital world is becoming more and more part of our daily life. So, we all know that the shared virtual worlds or metaverse, it's like growing. We see also that we know that the economy there is growing a lot, and it is estimated that in 2025, for example, the economy of metaverse is predicted to value at around $150 billion, and yes, it's next year. So we see that digital realm influences our work processes, our social interacting, our entertainment. Those are the three first areas I would name, and there is a high potential for, in a positive way, for example, for education, for healthcare, for other, I would call them good causes, but of course, with all the benefits and opportunities, the virtual world also poses its challenges and risks. And as virtual world opens possibility to interact without geographical limits, and still today, when we talk about constitutional rights, we still talk about the geographical territory, which is one of the three basic features of a national state. Just coming closer to the question, the Commission last year also announced that it would move forward, I would call it Euroverse, and this is what we call it is called more or less the same way everywhere, and that it would, this initiative aims to reflect EU values and fundamental rights and create open and interoperable metaverse. And there have been discussions have started about how we should frame the legal framework there. Also, from academia, there are calls that maybe we should think of digital constitution. But basically, it means that in this virtual reality, everybody can create their own world with their own rules at the moment. And we need to face this issue, which is coming closer and closer to us. So my question would be, what are your thoughts on the best way forward? Do we need to look for new approach totally, or new institutional framework, or we can adjust the present one? That it especially comes together with the topic of this panel, as I already cited, that we are united by the values, and at the same time we are very different as regards national identity. So, and in the digital realm, it all becomes very blurred. Thank you for your thoughts.
Thank you, Ilse, for such a challenging question, and dear colleagues who would like to somehow reflect about the future. Nicola, please.
Thank you. Well, thank you very much for the fascinating topic, and I think there will be more and more conferences discussing specifically the topics, the questions that you just put, because they are too complicated. So I just took the floor not to kill the time because we don't have much, but on the contrary to say that, in fact, what we need in the first place is an enhanced dialogue between the courts, and it is exactly what we are doing here. Because we can certainly not try to have our individual concepts in each case, especially domestic constitutional courts, but also this applies to the Luxembourg court and to the Strasbourg court. Definitely not. There are certain features that I would say distinguish the European digital constitutional identity, if I may say so, from the rest of the world. For example, our shared European attitude to the limits to the freedom of expression in Article 10 of the European Convention on Human Rights, which are rather alien, I would say, to the United States of America, for example, which is still the state that dominates the digital universe, so to say. That's one of challenges. But then there would be so many of them, and I think we can only arrive at a certain result through dialogue. Thank you.
Peter.
If I just may add one thought. 20 years ago, when the internet came into existence, many thought that national boundaries, national legal systems would be obsolete. And there would be just a new world without regulation and restrictions. After 20 years, we've seen that it is possible to impose European and national legal standards also in the internet. And I do not understand why just the change of a technical device and the switch to the digital world would make these principal aspects and foundations of our public life not valuable and relevant anymore. One thing which I may add, I don't understand why the European Commission has switched to call all the regulations acts now. If I recall it correctly, the Dutch and the French rejected the Treaty on the Constitution of the European Union because they didn't want this statehood appearance of the European Union. And if I look at the treaties, I don't see nothing about a Digital Services Act or European Media Freedom Act, but just regulations. This is not illegal, but I think it's weird. And it's a bit contradictory to what the people's and the member states wanted.
Thanks, Peter. And Martin?
I will not comment on the last issue, but because the question is already difficult enough. Just to add, the Venice Commission has begun to look into the matter because it has impact on many different fields, from the electoral field to judicial decision making, etc. There are no conclusions yet, so I will not convey any substantive message, but there are, I think, two things that I can already say. The first one is that there's doubt whether the starting point that is very often used, which is what is applicable offline should be applicable online, whether that can truly be maintained, whether it works in all situations. And perhaps there are situations where it doesn't work. It should still be the starting point, but whether it is an exhaustive answer to the question, I'm not sure. And that in turn would mean that you need a regulatory framework. And that in turn means it's not entirely up for courts, whether they're European or constitutional or otherwise, to be responsible, solely responsible for making that regulatory framework. I think I leave it at that.
Thank you, Martin. Let's move forward, and now Karina Palkova. Karina, where are you?
Here, not far. So, do you hear me? Yeah, you hear me. Well, first of all, thank you so much for your reports, for your speeches, and in my opinion, the roots of constitutional identity go back to Aristotle, because actually he insisted that the identity of a state did not depend on its, let's say, personality or physical issues or characteristics, but in general depends on constitution. And my question is, how should national constitutional courts balance the concept of constitutional identity within the European Union law, let's say, to ensure the preservation of the country's distinct legal and as well, let's say, constitutional traditions within the framework of EU integration? And how do you think, are there any dangers of this concept of constitutional, let's say, identity, taking into consideration geopolitical situation, let's say?
Martin? Let me start this time and then my colleagues can add. First of all, my answer to your first question would be, I don't think it's ordinarily a collision course. Both can be combined. I don't like this discourse, this character of the debate. It's either that or that. I think in 99.9% of the cases, it is a matter of choosing a treaty-compliant interpretation of your constitutional provision, with the obligations that the state indeed has freely entered into under international law. With regard to your second question, yes, there is an obvious risk, and I was already alluding to it a little bit, because I think constitutional identity sometimes is used or abused, I leave that up to you, to make a national sovereignty claim. I am therefore entitled to ignore the international duties that I entered into under international treaties. And there I would say it's a red line.
Well, I could only repeat what my Dutch colleague has said, just giving you the German example. As far as the constitutional identity is touched, or if it is touched, there is no balancing anymore. It's like human dignity, things, and therefore it must not be interpreted in a wider sense, so it cannot be abused in order to protect political or national sovereignty interests. What the Hungarians have done with their immigration policy, reclaiming national identity, was definitely an abuse of the institution. But every legal institution, also the primacy or the precedence of application, can be abused.
Thank you. And we are going forward, and Italian colleague Giovanni Petruzella, please take the floor.
Thank you, Mr. President. And first of all, the Italian Constitutional Court thanks you for the organization of this important conference, very useful for us. Thank you very much. And personally, I thank the speakers because they gave us good food for thoughts and to animate this debate. Then I will share with you some remarks on the subject. I observe that there are two different ways of conceiving the relationship between the identity of the Union and the constitutional identity of the member states. The first one sees them in opposition. The second, in a relationship of collaboration and mutual learning. And I think that all of us agree that the second meaning of identity should be used. Cultural, the constitutional identity, the relationship between distinct but complementary identities is at the very core of the European Union. And in this perspective, there is an historic judgment of the Court of Justice on the Portuguese Judges Association in 2018, which constituted a turning point in the constitutional construction of the Union, because it affirmed that the constitutional identity of the Union is based on the common values listed in Article 2 of the Treaty of the European Union, and more recently, in the judgment adopted by the Grand Chamber on February 2022, the so-called conditionality judgments, the court stated that Article 2 is not merely a statement of political guidelines or intentions, but contains the values that are an integral part of the identity of the EU as a common legal order, values that have concrete expression in principles, including binding obligation for the state. As the President of the Court of Justice, Ken Lehners, observed out of the court, the Union is first and foremost a union of values. In my opinion, there are important consequences of this vision of union as a common, as a union of values. First, values express a particularly strong form of integration. To have the values set out in Article 2 in common means not simply being part of a single market or an international organization that looks after common interest. It means being part of a European society. I quote Professor von Bogdandy, who argues precisely that Article 2 and European public law based on it are at the origins of what he calls the European society. Member states freely entered this society and agreed to share those values. And values, alike principles, do not provide for balancing or admit of being sacrificed for the sake of another value, such as the cultural identity of a state. And so I quote the jurisprudence of the Court of Justice concerning the rule of law. The rule of law doesn't admit, I am going to end, any kind of sacrifice. Anyway, the National Court, in my opinion, has, the Constitutional Court especially, has a role in specifying these values by the dialogue. I think that to bring our constitutional tradition inside the fabric of union law, we should use the preliminary the request for a preliminary ruling. And so I ask you how to strengthen this possibility for the Constitutional Court to bring our constitutional tradition in the reasoning of the Court of Justice. And then, what do you think of the principle of the equality between member states, which, in my opinion, is the basis for the monopoly of the European Court of Justice to interpret the treaty and the union law? Thank you very much.
Yeah. Peter.
Shall I answer? First and foremost, I'm a bit skeptical as far as the line of juiz português and the following is concerned. I understand that it was a device to help the problematic situations, to help with some aid in the problematic situations in Poland and Hungary, and it was the preparation for this jurisprudence. And I've got two hearts in my body. The one tells me it's good to maintain the rule of law. The other one is my legal conviction, which says me, well, the treaties have the Article 7 procedure. They want the governments to decide on the principal values, and neither the European Commission nor the Court of Justice. This leads me to your quotation of Armin von Bogdandy, with whom I've published at least 30 volumes. And he follows your fellow countryman Sabino Cassese with a very elitist conception of the European political model, which our French colleagues would call un gouvernement des juges. It is up to the judges to decide on the values and on the framing of European integration. And I doubt, and I am skeptical, that judges have the democratic legitimation and the acceptance to provide a legal framework which forces 450 million Europeans to live under certain conditions, even if I like these conditions. I'm not hostile against them, but I think this is up to parliaments, to the people, to voters. It should not be the elitist task of lawyers. And therefore, I also would think that the construction of the European Union as a creation by the member states cannot be revolutionized by just interpreting the treaties in a different way.
Thank you. So, dear colleagues, we have remained just 3 minutes, but it's okay. With the power given to me, I would plus 5 minutes. That's why we will proceed with 2 additional questions, remarks, and floor goes to Danute. Danute, please.
Thank you. It's okay? It's okay? Okay. Thank you very much, Dialdis. Because I was waiting for this floor for a very long time. I pressed the button, then it disappeared. Then it disappeared for the second time. Okay, I always have some technical problems. But first of all, I would like to congratulate the Republic of Latvia and the Constitutional Court of Latvia with the 20 years anniversary of the membership in the European Union. Our state and Estonia and some other states are also celebrating this anniversary this year. And I really think that we have to be very proud that we have some common European values and we can speak about it today, even discussing what does it mean and so on and so on. Because having the aggressive war in Ukraine, I think we understood what does it mean, especially for our Baltic states now. And for our colleagues who are coming not from the EU member state, I still would like to speak a bit about the Lithuanian core constitutional values, and I would not agree with my esteemed friend Martin that it's not so important to know what does it mean like the constitutional identity, but the most important is to know when it is involved or how to use it. In my opinion, in order to use correctly the notion of core constitutional values or fundamental constitutional values or constitutional identity, you have to know what does it mean. According to the Lithuanian constitution, core constitutional values are stated in Article 1 of the Lithuanian constitution. And here we have 3 very important notions. It's the independence of the Lithuanian state, republic, and democracy. In the jurisprudence of the Constitutional Court of Lithuania, the innate character of human rights has also been recognized as a fundamental constitutional value, forming a constitutional identity of the Lithuanian state. And what is more important is that the Constitutional Court of the Republic of Lithuania has also developed another very important constitutional identity aspect. It means that the membership of Lithuania in the European Union and NATO. And this membership is regarded as a political orientation of the Lithuanian state and recognized as a constitutional principle of the Lithuanian state. Why this is so important? This is so important because all these fundamental constitutional or core constitutional values, constitutional identity aspects are clearly related to the possible amendments of the Constitution, and the Constitutional Court of Lithuania has developed some very strong requirements for the amendments of the Constitution. It means material, substantial requirements for the amendments and also procedural requirements for the amendments of the Constitution, which in principle practically means that Lithuanian Constitution cannot be amended when there are some threats to my mentioned constitutional values. I think this is very important because this really, all these constitutional constitutional values forms the background of the Lithuanian constitutional identity. But of course, I have to confess that Lithuanian Constitutional Court is never arguing with the Court of Justice of the European Union, sometimes with European Court of Human Rights, but never with the Court of Justice. But in principle, we have this very specific our constitutional identity doctrine. And second aspect, what I wanted to say, it's of course to my colleague Mikola, as regards some cases of the European Court of Human Rights, as he has mentioned. Of course, I would not maybe agree with Lauci case because I was sitting judge in the second chamber, and in my opinion, the judgment in Lauci case of the second chamber is much more better. It's legal judgment. In my opinion, grand chamber judgment is a political judgment. And here we have some problems, as Martin has mentioned. For example, the Venice Commission opinion concerning like Hungary and its religious beliefs and so on. In my opinion, that your opinion is going against the Lauci judgment of the Grand Chamber. And here the problem starts. And okay, I will maybe stop here, I will not say anything more. But coming to the another judgment mentioned by you, dear Mikola, SOS, I think here also we have some problems concerning the shared European values or whatever you call them, because I think in this case, the European Court of Human Rights has developed a new principle, it's living together principle. And of course, here we can discuss the issue, whether this living together principle is also related to the French constitutional identity. I don't know whether we have here French representatives or not, whether it's like égalité, fraternité, or liberté, some aspects of these three core notions of the French identity. But in my opinion, what I wanted to say is that this living together principle, with whom I agree totally, but the problem is that if European Court of Human Rights in some particular judgments is developing a new principles, this can be dangerous for, in general, human rights protection, and especially to the uncertainty in the human rights protection, because the states, in principle, should not know the limits. But of course, these questions maybe will be discussed also in the second part concerning the European consensus. So thank you very much.
Danuta, thank you. Maybe dear colleagues who would like to answer, but in a concise manner.
Dear Aldis, I am entirely mindful of the fact that time has expired. But I wanted to thank Danuta, and it gave me the opportunity to perhaps nuance, because you misunderstood what I said in reaction to Konstantin. I didn't say that constitutional identity is not important. At least that's not what I wanted to say, because I know that for certain countries it is a tremendously important concept. It is fundamental to their entire legal system, the entire system of their constitution. What I did say is it is a very difficult concept to interpret, because it differs from country to country. It's not a uniform concept. And for me, the most important thing is, and that in that sense you're right, I think there's a huge difference between what is constitutional identity and when is it invoked.
So, and Peter is Ilgaus. Peter.
Thank you very much for the floor, and I express my gratitude briefly as well to the organizers for this wonderful conference and the invitation. And my comment, which I'll also try to make rapidly, is I'm wondering how much this discussion going forward needs to take into account that we are facing challenges such as climate change, military security and peace, war in Europe, and the transformational change of generative artificial intelligence, which this time is transformational in the sense that it can replace us at what we do best at thinking, writing, formulating, and that these are all transnational and even global challenges by their nature. The constitutional and national identity of our member states have been formed by our languages, our literature, our art, our territory, our nature, our democracy, and these are all threatened by the negative aspects of these developments. An approach that is centered, let's say, on a certain go-it-alone method of acting nationally everywhere it's possible, in the end, may not serve to be protecting and maybe self-defeating, because the very essence of our national identities can only be effectively addressed in the area of these challenges together on a European level, ideally in an ideal world on a global level, if we want to defend democracy and our cultural and natural environments.
Just perhaps one word. Thank you very much. That's just one sentence. Everything you said is of course extremely relevant, and well, I would have my priorities. I wouldn't put the war between whatever artificial intelligence and climate change. But that's my of course bias as a Ukrainian national. However, it only means that the courts, the constitutional courts, the Court of Justice of the European Union and the European Court of Human Rights must not stay in the ivory towers. They must understand what's going around them. Otherwise, they very quickly become irrelevant. Thank you.
Thank you. And Marina Papadopoulou, please, in a very concise way, because we are out of time frame.
Thank you. Thank you. I send my greetings from and thanks from the Council of State of Greece, which also serves as a constitutional court. And a very brief, already we stated the importance of political developments and international challenges on the constitutional identity of the countries and the general institutions. So there is a danger, and we already stated, witnessed this in my country, the danger of making discounts because of crisis, in the face of crisis, of economical crisis as we faced in Greece. And maybe now, because of this political crisis and the war in Ukraine, and how must we put some limits? The human dignity is a limit on these, the danger of making these discounts, because we already the reduction of wages in Greece, and maybe now we have to face some dangers on national security because of the political developments, and how we can put a limit on these dangers of making these discounts. Thank you.
Thank you. Thank you, dear colleagues. Well, I am not going to sum up all those questions, reflections, answers, and any contribution, because this is a question which is in the competence of my colleague Martin Paparinskis. But what is in my competence is to express deepest gratitude to our speakers. Dear colleagues, thank you for so fruitful discussions. 2 hours have already gone. And as Italian colleague said, good food for thoughts, but since we are human beings, we have to have good food for our beautiful body. Thank you. And yeah.
One more announcement. Dear colleagues, now it's time for one of the most family-friendly moments of this conference, taking a group photo, and please gather everyone as soon as possible on the stairs between the first and the second floors for the photo right now, please. And the second panel session will commence promptly at 2:15 p.m. Thank you.
it. Ladies and it is actually on. Ladies and gentlemen, in 10 seconds we will start our second panel. It's a final countdown. Dear ladies and gentlemen, welcome. I still hope that you have a very positive predisposition after lunch. And we will try to entertain you in the next 2 hours with interesting and important debate. Before we get started, I wanted to say thank you very much to the Constitutional Court for inviting me again. I was here in September at the conference that Judge Gnatowski mentioned in his presentation, and I'm grateful to be back. And I think that it means that I didn't annoy judges enough in my previous intervention, so I will try to do it now. And I think I recently finished a big research project on feedback loops between the European Court of Human Rights and national courts. And participation in conferences like this actually creates a feedback loop between the court and Judge Gnatowski as a representative and plenty of members of other courts here. So this is the important aim and value of this conference. So let me go to the topic of this panel. The topic of this panel discussion is European consensus shaping the European public order. And I have to say that this is very much in line with my own research agenda, because I published 2 long monographs. One of them was on European consensus, and the second one was on European public order. So in the next 15 minutes, I will have to summarize these 2 long monographs, and that's it. That's, the topic is exhausted. What can be easier in 15 minutes, right? And I also, since I'm a moderator, I have to be on time, because if I'm not on time, what legitimacy I would have to stop other speakers from going over time? And I've been told that legitimacy comes from example, and this is very, very important. So in this short presentation, I will start with European consensus, its methodology and role in the case law of the European Court of Human Rights. And then I will move on to discussing European public order. And then finally, I will do something that I haven't done in my monographs, merge these 2. So first, let's look at European consensus. In the book from 2015, I argued that European consensus can enhance the legitimacy of the European Court of Human Rights, something which George probably will have something to say about. And in order to achieve this enhanced legitimacy, European consensus, in my view, should be based on real evidence, and it should be consistently applied in the case law. European consensus is a tool of interpretation of the convention that the court uses in its decision-making, and the reason for application of European consensus is that the meaning of the convention terms or the interpretation of the convention can be linked to the solution, or rather various solutions that are supported by the majority of 46 contracting parties. This support to a particular solution is identified through comparative analysis of the laws and practices of the contracting parties and international law. European consensus, I argued, is a rebuttable presumption, which means that the contracting parties are presumed to be in violation of the convention if their solution diverges from the solution adopted by the majority, unless they can provide sufficient and weighty reasons for such divergence. I'll give you a quick example. In judgment of Bayatian versus Armenia, the court was considering whether the prosecution for conscientious objections to military service is contrary to Article 9 of the European Convention on Human Rights. Prior to this case, the court answered negatively to a similar question, but here, in order to change its approach, the court established that there were only 2 countries in Europe which criminalized conscientious objections and didn't offer any alternative military service, and for that reason, the court found a violation of Article 9. Unlike some learned colleagues, I think that European consensus is a useful tool of interpretation of the convention, but one of the core issues of contestation here, even between supporters of consensus, is its methodology, how consensus can be identified. Identification of European consensus can be divided into 3 steps: identification and application, from my perspective. It's preliminary stage, stage of assessment, and stage of deployment. At the first stage, the court prepares comparative law materials that describe the law and practices of the contracting parties. It is a comparative exercise which happens behind the scene, and the court usually only includes a very short summary of often quite lengthy reports prepared by the registry. These reports themselves are confidential, so you cannot have access to them. The court's approach to comparative law has become more professional over years, I would argue. The court has invested quite a few resources in the creation and development of the so-called research division within the court's registry, which prepares these independent comparative law reports upon the request of Judge Rapporteur in cases of high importance. In my monograph, I propose that the court contacts apex national courts with the question about their national law. The European Court has accepted this idea, although it's very possible, even plausible, that they came up with this idea independently of me. And now those working in apex courts and those who are members of the so-called Superior Court Network of the European Court of Human Rights have to answer the request on their national laws. At the second stage, the court analyzes the outcome of comparative study and decides whether consensus can be established. The court doesn't need a unanimity to establish this consensus. In a number of cases, a trend to a particular direction has been enough to trigger European consensus arguments. This stage is also not automatic, and the judges have to decide on a number of dilemmas, including whether the number of states is enough to constitute consensus, the level of abstraction that European consensus should be established on. I argue that European consensus is possible on the level of principles and the level of rules. If consensus is established at the level of principle, it reflects a general agreement of the contracting parties in relation to a certain fundamental issue that might need further interpretation. For example, the contracting parties might agree that national minorities must be protected, but this principle can lead to various specific outcomes, even sometimes mutually contradictory. The level at which consensus or lack thereof is established might have a direct impact on the following stage, because consensus on the level of rules is much more straightforward and can claim a higher degree of persuasiveness in comparison with consensus on the level of principles. Then, at the stage of deployment, the court considers whether consensus or lack thereof should influence the outcome of the case. It is argued that European consensus establishes, again, a rebuttable presumption in favor of regulation adopted by the majority of the contracting parties. This means that European consensus is not applied automatically, and the judges retain a great deal of discretion in applying it. Having said that, the court should not apply consensus arbitrarily, and if the court decides not to follow consensus, it has to clearly and convincingly explain the reasons. And probably it's not always the case that the court does that. Second point, European public, so we are done with consensus for a moment. Second part of my presentation is about European public order. Okay, so I was very, thank you. I was very nice and optimistic about European consensus. I am much less optimistic about European public order, I have to apologize. My take is more pessimistic, as I said. My interest in this concept sparked an oft-repeated phrase of the court that European Convention is a constitutional instrument of European public order. The court said that in the case of Loizidu versus Turkey, for example, but also it's repeated many times. Some judges of the court, especially Judge Paulo Pinto de Albuquerque, liked including this concept in his dissenting opinions too. And my genuine question, similarly to the question that I asked the first panel, was, what is European public order effectively? What legal consequences references to European public order might have? And how the European Court of Human Rights can shape it, yeah? So the core argument of my second monograph, looking at European public order, was twofold. First, I argued that it's hardly possible to define European public order. And therefore, using this notion in the court's judgment is not helpful for the clarity of the court's reasoning. If one accepts the fact that clarity is one of the factors that affect the legitimacy of the court's judgment, then such fundamentally vague notions can undermine such legitimacy. Under European public order as legal concept, and I underline legal concept, I mean that it is deployed by the European Court in its case law as a justification for a certain outcome of the case. For example, in some early cases, very early cases, the court declared an application inadmissible in accordance with Article 35. It wasn't Article 35, but it is Article 35 now, so I use Article 35 of the Convention, and then stated, and this is important, that no reasons of European public order would justify declaring it admissible. So in a way, the court treated European public order as an argument that can justify a departure from the strict interpretation of the wording of the Convention. Where the court uses public order in a legal sense, it needs to establish some applicable scope and common understanding of this concept. In other words, such utilization requires clear meaning. However, it has never been done, and I argued that the deployment of European public order in legal sense in the case law of the court should be avoided. We'll see how that goes. The court keeps repeating that they deal with European public order in their case law. Second, and conversely, so that was my first approach. First approach to European public order as a legal concept. Second, I thought that European public order can be used as a descriptive notion which is not expected to lead to any legally significant outcomes. Here, European public order is seen as a set of fundamental, very highly abstract values shared by the contracting parties. In this respect, the monograph argued that ECHR does impact the understanding of these shared values, but such impact cannot and should not be the strategic aim of the court. So, where does it get us? The meaning of European consensus can be quite vague at times, but not as vague, as imprecise as the meaning of European public order. I read quite a bit on legal vagueness, and there are degrees of vagueness there. And of course, many legal phrases and many legal concepts are vague. That is why I argued that the court should continue using the former, meaning consensus, as a legal concept and stop deploying the latter. However, it would be a hypocrisy of me to say that they are completely disconnected. At least they don't look as such, right? One can hypothesize as how they can be linked to each other. And I have three propositions here, very, very briefly. I know that I'm running out of time, but very briefly. First, European consensus can be seen as a representation of European public order. If that was correct, the court would use the notion of European public order and European consensus together. This is perhaps an appealing argument, but the court almost never used them in the same sentence, in the same paragraph, in the same, very rarely even in the same judgment. I used the keywords European public order and European consensus in HUDOC database, and it gave me only 5 judgments in which they meet. Well, they are mentioned in the same judgment, but never in relation to the same argument. Of course, my search was a bit harsh and not very rigorous, but this throws some doubts into the proposition that European consensus is actually a representation of European public order. Second, European consensus is not the same as European public order, but rather the tool by using which the court tries to solidify European public order. And it comprises of the most fundamental values. For instance, and I will briefly quote the European Court of Human Rights here, in the recent case against Poland, the court stated, as the convention is a constitutional instrument of European public order, the state parties are required, in that context, to ensure a level of scrutiny of convention compliance, which at the very least preserves the fundamental foundations of that public order. One of the fundamental components of this public order is the principle of the rule of law, and arbitrariness constitutes the negation of that principle. Having said that, European consensus can be identified on much more precise level of rules. And moreover, it is more convincing when it is concerned with very clear rules, as I argued before. So my final hypothesis is that the court sees either no or very little connection between European consensus and European public order. And this reading is quite appealing, not only because these concepts do not meet in the reasoning of the court that much, but also because their roots to the European Court of Human Rights case law were very different. They appeared in different cases in different times. Thank you very much. I spoke for 3 more minutes that I was allowed to, but I hope we will be able to catch up at some point later on. Okay, now I am switching my virtual heads from making introductory remarks to the chair and moderator of this esteemed panel, and I would like to invite our first speaker. Our first speaker is he is the judge of the Constitutional Court of the Republic of Latvia since 2017. His name is Artur Skučs, I should say. Judge Skučs completed his doctoral study in the Faculty of Law at the University of Latvia in Aarhus University in Denmark. His doctoral degree was on balancing right to freedom of speech and hate speech. I think it is one of the topics that can be endlessly discussed and considered. In the past, Judge Skučs had a very successful academic career and also worked at the Ombudsman's Office of the Republic of Latvia as an advisor to the Ombudsperson. And he is also a lecturer at Latvian Judicial Training Center and also an ad hoc judge in Strasbourg. So also partially a judge of the European Court of Human Rights, I have to say, and author of multiple publications on the topic. I can carry on doing that, but I will probably give the floor to our first speaker. Thank you.
Thanks, Konstantin, for introduction. Dear colleagues, dear participants of the conference, thinking about consensus, I have a privilege sometimes to be in Venice Commission and as a substitute member, and also to be in a Fundamental Rights Charter expert group in Vienna. And when you go to Vienna, sometimes people think that all world now is about charter. They say, convention is an old instrument. We now have a charter, we should apply charter, and the reality seems quite that we all applying EU charter nowadays and not a convention. When you go to Venice Commission or to Strasbourg, you see the different reality. So I would say there is a way to go to, not to find probably consensus, but avoid, I would say, unnecessary competition, but to strengthen each other. But coming to consensus, it's the way I choose to speak about it was probably from perspective of Latvian case law, from the judge of the Constitutional Court, because I knew that I have two distinguished speakers on a panel on EU law, and also Georg Lecas, who had a book on Strasbourg case law, not to take something away from them, to leave them. And so indeed, the concept of European consensus have been long used by the Strasbourg court and as an element of a living doctrine of the convention. However, from what Konstantin already mentioned, I think that also from the point of view of national judge, I think the methodology, how the court arrives to the concept of consensus is not always very clear. And I think some more clarity would be needed, both for us, national judges, and also for, I would say, also for and to strengthen the, credibility of the Strasbourg court also itself, because as a former president, Robert Spano, has stated that states are increasingly dissatisfied today with international courts deciding on national matters, and we can see these, I would say, attacks on pressure on Strasbourg court, also including one. First, I will look at the issue of European consensus from addressing two issues. First, very brief on the role of consensus in European system. And secondly, way I would say we use, we don't really clearly say it's a consensus, but analogy of consensus in our jurisprudence of our court. And it was already stressed in the first panel today that as a today, as the judges of highest courts of EU member states, of Council of Europe member states, when deciding on interpretation, application of fundamental rights, we find ourselves in this multi-level system of fundamental rights protection. We have to look at the Strasbourg. We cannot afford the lower level of protection, but if the case concerns EU issues, we also have to look at the Fundamental Rights Charter and also not allow a lower protection. And what role European consensus plays in this multi-level system and interplay between national, I would say, and transnational courts, I would say that European consensus serves as a tool for convergence of fundamental rights within this multi-level system, which is based on European shared values. And as we discussed already in first panel, as long as we go to general principles, we can find a lot of common shared values like democracy, rule of law, human rights, independence of judiciary as evidenced by recent case law of Luxembourg court, but also of Strasbourg court. However, differences arise when we come to interpretation of the scope of the existing rights, for example, to right to inviolability of private life and legal recognition of same-sex couples, or when we decide on emerging or contested rights, be it sensitive moral public issues on such as which concerns actually life and death, access to euthanasia, access to abortion, or access to surrogacy. I mean, we could really find differences on these issues on European level. I would say the European consensus, the way I see that, I see it as a part of the dialogue between national courts and international ones. Of course, as Martin Koyer said, it might be also I never looked at myself as a driver, and there is somebody navigating me, or Google Translator, but you know, probably it's also, at least we try to see it in a way that it is a dialogue, and at least if I look to the latest decisions and judgments of the Latvian Constitutional Court and the way the Luxembourg and also Strasbourg responded to that, I would see that I see these dialogues, that also as far as we go to constitutional identity, also cases, we see this understanding of both in Luxembourg or also in Strasbourg, I would say. If the court, yes, as I said, I see it as a part of the dialogue. If the Strasbourg court, of course, establishes a consensus, it narrows down the margin of appreciation of the states. At the same time, the Strasbourg court recognizes the potentially sensitive moral or ethical issues that case may be present at the national level and where consensus has not been reached, allowing for greater margin for states. I could just mention one example from last January, judgment Y versus France, where the court acknowledged the lack of European consensus today, and as regards obligation for government to ensure possibility of registration of third gender category. I have, honestly, when I researched, I have less findings as regards the Luxembourg court, why, for example, the source as common constitutional traditions is used in so little cases, but I hope our colleague Matej Spuner will elaborate on this. So I'll proceed with a few examples related to the search for consensus, or as I said, we don't use it clearly, such concept, but analogy with that from the case law of Latvian Constitutional Court. And we look for, I would say, when we look for comparative analysis over the common grounds in other member states, it's of the Council of Europe or EU, it's not in every case, it's not very common, and but occasionally we do that, and this may serve, I would say, two purposes. First, to seize the developments in other member states. Of course, it's a very complex exercise. I mean, we use a Venice network of constitutional courts, but I would say having the knowledge of legislation in another country is not enough. You have to know how it's applied, so it's really, you can get to wrong conclusions just if you have the laws of all 27 member states. The best solution is to talk to colleagues. That's what we are doing now. As I said, we occasionally do that, but of course the Constitutional Court has actually acknowledged that developments in other member states are not decisive for the conclusions of the court because social, historical, and I would say also geopolitical context today in other member states might be different. And the second, I would say, analysis of a common ground in other member states might also serve as an additional argument or give additional strength for our judgments when we change the jurisprudence. So we see the developments in other member states. I will mention two recent examples yes, where we actually looked at the development of common ground in other member states. The first one was related to, I would say, ban for soldiers who are in a professional military service to join political parties. When we looked at the legislation and practice in a number of member states, I would say the picture is very, very diverse. There are countries like Germany, Netherlands, where there is no such ban, and there are a number of countries where such ban, I would say, still exists. So I would say from that perspective, I would look, the state definitely has much more freedom in that sense. But this is, as I said, it's only one of the elements. It's definitely not the decisive one. But also taking into account other factors and also the current geopolitical context where we are actually in, the court concluded that the need to maintain a politically impartial military did not violate applicants' right to freedom of association. The contrary example, I would say, is a case which concerns the prohibition for members of parliament who refuse to receive COVID-19 vaccination to participate in parliamentary meetings, including the ones which were held online. As a judge rapporteur, when I examined because there were a number of restrictions during COVID-19 times, but there were use of masks, distancing, but I didn't find any states, actually among Council of Europe and also EU member states, where members of parliament were prohibited to participate even in online meetings due to COVID-19 restrictions. And it's true that situation in Latvia and challenges, especially at one point, were very severe. We were experiencing the highest COVID-19 rate and in Europe and a very low vaccination level. Therefore, I would say, in theory, circumstances and reasons for might justify a different approach. However, the court found also that imposing such far-reaching restrictions on the rights of elected parliamentarians was disproportionate, and stressing also the significance, allowing different views to be held by parliamentarians and people on this issue, and debated, to be present in a parliamentary debate. And the third case, which is for Latvian audience very well known, and I would say most debated case, and very much criticized by part of society and politicians, is a court's case on recognition of, on the right of, we call it very briefly, of same-sex partners, recognition of same-sex partners So, in these judgments, as I said, it was very much criticized by the part of the society and politicians, saying that the court was too active in this case. But I would say, in this case, we didn't really refer to consensus or to comparative view. We much more use the notions of human dignity and non-discrimination. But we adopted this case, I would say, just 2 years before the European Court of Human Rights Grand Chamber case of Fedotova versus Russia, where the Strasbourg Court found a clear and going trend as regards the obligation of states to legally recognize same-sex couples. So I would say at the time when we were adopting decision, it wasn't really clear that there is a clear consensus at the Strasbourg level. At least I wouldn't say so. There was Oliari versus Italy, which was very much narrowed down to, at least the way I read it, to Italian situation. So in principle, we would infringe the convention if we would have decided otherwise at that time. So it's a question how we actually could as the national judges predict that there exists already consensus there, and before the Strasbourg Court actually formulates it. So I would say there are a number of questions regarding methodology and criteria by which court establishes the existence of European consensus. As already Konstantin mentioned that how many states are necessary, which legal sources and which international treaties you take into account also in establishing consensus. So that would be definitely helpful that we as the national judges can reach the same conclusions as the Strasbourg Court. So it's not really, it was I think highlighted in the first panel, it's not everyday case, so it's really exceptional. But in these exceptional cases, that would be really helpful. In conclusion, I would like to refer to former president of German Constitutional Court, Andreas Voskuhle, who said the emergence of European consensus is not a one-way process, with national courts asking questions to the Strasbourg Court or to Luxembourg Court, preliminary questions. In this multi-level system of fundamental rights protection requires all actors, including national courts and European ones, to refrain from isolationist approach and embrace openness and dialogue. And we as judges of highest national courts should, and indeed we do, interpret the rights in line with changes in a society, thereby not only ensuring effective protection of human rights at the national level, but also influencing the emergence of European consensus. Thank you.
Thank you very much, Judge Cruz. I will not give my comments and remarks now. The only comment I have to say now that it was perfectly from a perspective of timekeeping. So thank you for that. Now, in the past, when I was preparing to moderate panels like that, I would sometimes go and ask ChatGPT. We talked about AI. ChatGPT about our speakers and what ChatGPT knows about them. And then at some point I asked ChatGPT about myself to make sure that so I asked ChatGPT, who is Konstantin Degtyarev? And ChatGPT was very flattering, saying that leading world authority in European Convention on Human Rights, which was very nice. But then it started listing my publications, which were not my publications, unfortunately. And since then, I stopped doing that, and I go Googling people old-fashioned way. And I Googled our next distinguished speaker, Maciej Szpunar, the first Advocate General of the Council of Europe. And among other things, distinguished things, I found that on the Wikipedia page, well, first of all, Professor Spooner has a Wikipedia page, that's already something. And the second thing, it says that, among other things, it tells us that he was awarded Officer's Cross of the Order of Polonia Restituta. So, and I saw the cross, it looks very nice and very impressive. Apart from this minor detail, Professor Spooner did his degree at the University of Silesia and College of Europe in Bruges. He was a visiting professor in Cambridge, the University of Liège, and European University Institute. He has a very distinguished academic career on board of many academic journals, and he was appointed as Advocate General of the Council of Europe, it doesn't exist, of the Court of Justice of the European Union in 2013, so I'm delighted to welcome Maciej Spooner.
Thank you very much, distinguished guests, President Lavins, dear Aldis. Thank you very much for inviting me again to Riga. I feel very privileged. It's also thanks to my distinguished colleagues from the Court of Justice that I have the pleasure of being in Riga, and not only to be here, but also to share with you some of my thoughts. The title of my panel is European Consensus Shaping the European Public Order, and at least my impression is that as a member of the court, I'm primarily asked to deal with the issue, how is the changing European consensus accommodated within the legal system of European Union? My presentation will be divided into two parts. In the first, I will address the specificity of the Union law in the context of the formation of this consensus. It will require taking into account the specific role of the Court of Justice, for which the interpretation of fundamental rights is not self-standing. We depend on the scope of EU law, and as our President aptly put it, the Charter of Fundamental Rights is the shadow of EU law. It is only binding on the courts of the member states where they are implementing union law. It is fair to say that this first part of my presentation will be more descriptive and will probably deal with the issues that you are already familiar with. Of course, it doesn't mean that these issues are without any controversy, but in the second part, I decided to address a particular issue that illustrates an aspect of consensus building that is not obvious and that is also related to the specificity of the Union as a supranational polity. It also stems from the fact that when we use in the title term European public order, it has a different meaning, so I took an advantage of look at this notion from another perspective. I will therefore refer to a case that is currently pending. I know that as an AG I should avoid commenting pending cases, but since my opinion is already rendered, I will avoid presenting my own opinion on this issue, but simply identify the challenging that this pending case is posing. So let's start with the first part. I do not intend to delve into the details of the concept of European consensus resorted by the European Court of Human Rights when interpreting the Convention. Suffice it to state that here the Strasbourg Court, with the concept of European consensus, developed, refined and calibrated over the years an interpretive tool which involves considering the common ground in laws and practices of member states on specific issues. The Strasbourg Court resorts to it when the convention is unclear, that is, when the convention itself is unclear or lacks established precedent, the court may consider member state practices. And my on no account revolutionary point of departure is that historically, in EU law in the early decades, there was no need for the Court of Justice to search for a European consensus in our case law. In this respect, the legal order of the Union fundamentally differed from the Convention. The Strasbourg Court is, put in figurative terms, the judicial monitoring mechanism for the Convention. Interpreting fundamental rights because of their very nature is, by definition, an extremely sensitive task, probably more than most other areas of law. Fundamental rights are a direct emanation of history, values, and social considerations. These differ from region to region, from state to state. Ergo, finding a European consensus is a part and parcel for a transnational court such as European Court of Human Rights. If this court is to set certain standards across now 26 member states of the Council of Europe, common denominators must be found, while at the same time leaving states enough room for maneuver in pursuing their policies. I would argue that the Union, and in particular our predecessors, European Economic Community, the European Community, did not have this issue. Here, a number of states got together to pursue a list of aims defined in the treaties. One of these aims was consensual. It was the creation of customs union, internal market, competition policy. In early days, whenever member states wanted to deviate from this consensus, it was for the court to adjudicate, for the Court of Justice. In particular, via the principle of proportionality, the court found solutions. This was often a very difficult exercise, but it was easier than having to define a European consensus, as the consensus was more or less defined in the treaties, what we agreed about. Over the time, things changed. The reasons for this change are twofold. They both have the same root. It is what political scientists would call functional spillover effect. Or put it differently, the Union was a victim of its own success. First, in the framework as provided by the initial treaties expanded and started to breathe, increasingly economic operators started to invoke the economic freedoms against the member states. And all of a sudden, the court had to deal with things which were no longer internal market in the narrow sense, but rather the way of life, questions of governance and how to run society. Thus, just to take two striking examples of many, the court was asked on questions as tricky as Sunday trading in the context of free movement of goods, or abortion in the context of freedom to provide services. How did the court deal with such cases? The court dealt with those cases in a very pragmatic manner, which can be described as hands-off. Rather than seeking European consensus, it found that these cases did not fall into the scope of the application of EU law, or more precisely, fundamental freedoms. Thus, in seminal Keck judgment, we invented so-called selling arrangements which are completely outside the scope of EU law. Equally, in the famous Grogan case on abortion, the court established that the link between services and abortion was too tenuous, was too indirect between the advertising campaign for abortion clinics. Secondly, as the Single European Act of 87, the Union competences continuously expanded with the treaty revisions, in particular in the area of freedom, security and justice, including asylum, migration policy, or European arrest warrant. In addition, the entry into force of the Charter contributed to this development, as any situation falling within the scope of EU law must comply, and therefore, if need be, measured against the Charter of Fundamental Rights. Furthermore, we should keep in mind that contrary to Strasbourg Court, the Court of Justice is not a human rights court in the narrow sense. Its primary mission is not to protect fundamental rights, but as stated in Article 19, to ensure that the interpretation and application of the treaties, in the application and interpretation of the treaties, the law is observed. It is obviously that fundamental rights often play a role when the court carries out its mission, but they are only one aspect of many. Next, I would like to illustrate the challenges that the court is facing when it has to find the European consensus on the matter currently, and I would refer to the famous judgments of Arjbita and Bunagi of 2017 about the general ban by a private employer on visible religious symbols in the workplace. It should be stressed here that contrary to the Strasbourg Court, the Court of Justice is not simply, could not simply afford the member state the question of large margin of appreciation. This is so because the Court of Justice is, as we see from Article 19, the ultimate authority in interpreting EU law, and in casu, the Equality Employment Directive. The Court therefore had no choice but to lay down in autonomous and uniform manner the correct meaning of religious discrimination under the directive. This implied that the court had to determine for the entire union law the correct balance between these two individual rights that were implicated, right not to be discriminated on the basis of religion and freedom to conduct a business. So the court was asked to reconcile this French concept of laïcité and the German neutrality coming from the Weimar Constitution. Of course, in deciding these cases, the court tried to leave some room for maneuver for the member states, but nevertheless, it was our task to strike the balance and to define precisely the scope of the application of these directives. And now let me refer to the pending case, because I think it shows another dimension of this exercise of building consensus. And this brings me to the case Real Madrid, a French newspaper's pending case. I know that Ineta is sitting on the bench. Le Monde published an article in which a journalist claimed that football clubs like Real Madrid and Barcelona had been involved in doping. Real Madrid and its doctor sued Le Monde for defamation. After proceedings before the Spanish courts found in favor of the claimants and awarded almost 400,000 euro to Real Madrid and 40,000 to a member of its medical team. In 2018, Real Madrid sought the execution of the Spanish judgment before the courts in Paris. And the President of the Court of First Instance allowed the execution. The Cour d'Appel overturned the decision on the ground that the penalties at issue had a deterrent effect on the involvement of the defendants in the public discussion of matters of community interest, and therefore they manifestly infringes French international policy. Real Madrid appealed to the Cour de Cassation, to the French Court of Cassation, which in essence asked the Court of Justice through preliminary ruling whether some provisions of Brussels I regulation and Article 11 of the Charter must be interpreted as meaning that the member state can refuse the enforcement of a judgment for breach of the freedom of expression guaranteed in Article 11 of the Charter. So this pending case is of course extremely complex. It concerns a variety of different notions like ordre public, mutual trust, fundamental rights, the interplay between various fundamental rights. But let me present some challenges in this case that poses with regard to European consensus and are important from the point of view of European public order. In a nutshell, we are dealing here with the question whether a member state can invoke its public order, or sometimes must invoke its public order, in order to refuse the enforcement of a judgment rendered in another member state that allegedly infringes freedom of media, a fundamental right protected by the Charter, by the Convention, and also by national constitution. The picture is much more complicated by the fact that there is another fundamental right that pleads in favor of the enforcement, and that is Article 6 of the European Convention, including a Latvian case, Avotins against Latvia. I think you already left the court in Strasbourg. The Strasbourg court confirmed that Article 6 also comprises the right to have your judgment, your decision enforced in another member state. So that pleads in favor. Another element that pleads in favor of the enforcement is a mutual trust. Mutual trust which the member states accord to one another legal system and institutions. Mutual trust means that in the event of misapplication of national EU law, the system of legal remedies in each member state should afford and should guarantee the sufficient protection to individuals. Brussels I is the regulation Brussels I is one of many instruments which are based on the mutual trust, and one of the emanations of this mutual trust is the provision that says that under no circumstances may the foreign judgment be reviewed as to its substance. And finally, what also speaks in favor of the enforcement is the presumption of equivalence that to a certain extent was accepted by the Strasbourg courts as regards the union, starting with the Bosphorus and another case, Lithuanian, Latvian case that I just mentioned. And before I turn to the analysis of the content of European public order, public policy, let me draw your attention to one important aspect illustrating the complexity of application of the Charter. In this case, in the case at hand, there was no doubt that the Convention was applicable in its entirety to the proceedings both before Spanish and before the French courts. But the problem from the point of view of union law is much more complex, because Spanish courts, when they rendered the judgments, they did not apply the Charter. The case concerning defamation, right in personalities, which are completely excluded from the scope of EU law, and only when plaintiffs ask for the enforcement of the judgment in France, the Charter started to be applicable because they relied on the EU instrument, the regulation Brussels I. So the Charter started to applicable only in the procedure of enforcement. And in this context, the question that the court will have to deal in this case is to what extent the French courts, relying on the European public order, public policy, should refuse the enforcement of this decision in France. And of course, it has been always understood that member states may refuse the enforcement of a foreign decision relying on its own public policy. But in this case, we are facing with another problem, that is whether this public policy, public order, is purely national. And in this case, I have reiterated a thesis that currently we are faced with the formation of something we could call European public policy, public order. A secondary issue is whether it stands alone or is a part of the policy of the public policy of the member state. What is important in that this concept is shaped by the Court of Justice, and in many situations, member states might be obliged to invoke the public order clause in order to refuse the recognition or enforcement of a judgment rendered in another member state. It has been already said this morning that, as confirmed by Article 2, there is a common core of values shared, respected, and protected by all member states, which define the very identity of the European Union. And here I refer to the conditionality judgment of the full court. It is difficult to find a more representative example of the values shared by the member states than those reflected in the Charter. Sometimes it is referred as EU identity along the lines with national identity, which is mentioned in Article 4.2 of the treaty. My proposal in this case was simply that French authorities were under obligation to refuse the enforcement of this decision to a certain extent when the French public policy is supplemented by the need resulting from the common traditions of the member states, the Convention and the Charter of Fundamental Rights. Let me conclude by saying that I have no doubt that a certain consensus on the protection of fundamental rights is an essential element of the functioning of the European legal space. Its necessity manifests itself in many dimensions, and it is of course a matter for discussion in a group such as ours to determine how we should co-shape this concept of consensus, and for this reason, congratulations and thank you very much for organizing this conference. Thank you.
Thank you very much, Professor Spooner. I got two very, very interesting and thought-provoking presentation. I got two main lessons for me from your presentation. Lesson number one is that we shouldn't look for universal solutions to different courts. And consensus that might work for the European Court of Human Rights might not work for the European Court of Justice or Court of Justice of the European Union. And the second lesson is in relation to the final part of your presentation, is in that European public order is somewhat very closely relevant to something, to how it is used in private international law. And this is exactly as a trumping card for application certain foreign laws. But I thought a lot about this meaning of European public order, but I'm not sure that the European Court of Human Rights often, when it refers to the constitutional instrument of European public order, actually uses European public order in this particular sense. Although it's like false friends, right? Like they look the same, they're called the same, but they're really different in. They have many things in common, but they also have very specific differences which make them really problematic to compare. Now, sorry for my intervention on that, but I thought that it's important to say now. The next speaker on my list is Professor George Letters. He is a professor of the philosophy of law at the University College London, which is a very good university, at least they think so. And I should stop making these jokes actually. Because there are at least two people from University College London, and I'm really outnumbered there. I know George for very many years, and we met for the first time when he wasn't yet a very authoritative and important professor, but he was a rising star at the time in jurisprudence and human rights. And actually, I have to say that I'm very grateful to George. Because when I was writing my PhD, a huge chunk of my PhD was dedicated to him. It was dedicated to his work, and it dedicated in a way that I completely disagreed with him. So, but this is excellent, because otherwise I would look like an idiot fighting windmills, that arguments that don't exist. But thanks to George, who published his wonderful book, which was sitting next to my computer, I could actually write something that had background to it. And George was kind enough to send me his presentation before, and this actually presentation reminded me how brilliant and intellectually stimulating it is, and why I disagree with it too. So apart from being a professor in UCL, Professor Letzas was a visitor in New York University. Professor Letzas also has a Wikipedia page, I have to say, but there were no juicy details to comment on, unfortunately. So without any further delay, I will pass the floor to Professor Letzas, please.
Thank you. Dear President of the Court, dear esteemed participants, I'm very honored and grateful for the opportunity to participate in this very distinguished conference. It is very rare to be in an event where the beauty of the space matches the warmth of the hospitality, as well as the quality of the discussion. This last one, the quality of the discussion, might be slightly affected in the next 20 minutes, but I take comfort in the fact that the average has been so high already that the hit will be very minimal. My argument today is very simple and very clear. I believe consensus is a very inappropriate interpretive tool for the European Court of Human Rights. I realize how provocative and controversial this claim is. As my esteemed colleague just mentioned, it goes against the current, it goes against, at least on appearance, how the court uses consensus. But I want to try and take 20 minutes to explain why I believe that. And interestingly, I think, for our purposes here, I'm going to argue that the reason why it's inappropriate is because it's antithetical to the values of human rights and the rule of law. So that links into the theme of the convention, of the conference. Now, before I try to explain why I think consensus is inappropriate, I want to begin with two broad remarks to set the discussion today in a bit of a context. Perhaps a context that the distinguished judges could not really articulate because of their office. The first thing I want to say is that the values of Europe, what unites us, has been under threat, I think, the last 15, 20 years. And by values, I mean basically the holy triad: democracy, human rights, and the rule of law, which are not just slogans and catchphrases, but we have come to realize their value and why they're important through a particular history. And I want to mention here two things which we should never forget, and it's worth reminding, that one was the experience of totalitarianism in the 20th century, that horrible experience and the atrocities committed. And the second, which I think is really not really discussed much, is a long process, still incomplete, of European nations moving to a more secular institutional structure, by which I mean a realization that things like religion and ethical choices of a person are their own business as opposed to the business of the state. This is an incomplete process. We're still going through that, I think, but it's a helpful background for me to try to understand when a case is controversial before Strasbourg, or why it is that it's controversial. And we must bear this in mind. Why are these values under threat? I think because the last 15 years, a number of crises, from the financial crisis to problems with mass migration in Europe, and then to COVID, these circumstances have created uneasiness amongst European people, citizens, individuals, and these circumstances are very fruitful ground for elected politicians to try to exploit them electorally and try to ponder to the fears and uneasiness of the electorate with a view to get elected. And the rise of populist parties, I think, is something that we all worry. It reminds us a lot of the period before the Second World War. And there is increasing, I think, worry about how well we can stand up to our values, given the incentives that politicians have to play a line to the electorate that is directly contradicting these three values. One example here, I think, is that populists typically don't like institutions like courts and representative democracy. They want direct appeal to the people. Whereas the whole, I think, idea of European values is that the will of the people is mediated by institutions like the legislature and the courts. And I think that's something that we have to bear in mind. The second thing, border observation, I want to put in the picture is the elephant in the room, I think, for me, which is not discussed much in the European context, but I live on the border, if you like, on the bridge between the US and Europe in the UK, and the constant discussion amongst academics is not how courts should concretize the common values, but whether they should. And in academic circles, since the 90s, Jeremy Waldron raised the question, why should courts decide about rights, given that reasonable people disagree about them? Judges disagree about them, people disagree about them. Why courts and not elected politicians? Why not courts and not everybody through our representatives? Now, this is not really discussed here because, of course, we have the European Court, we have the Court of Justice of the European Union, we have national constitutional courts. But I think we live now in a world where it's getting smaller and smaller, and the challenge to judicial legitimacy is discussed everywhere. And it seems to me that it's not absent in the discussion of the Strasbourg Court. I interpret the preoccupation with the margin of appreciation and consensus as a knee-jerk reaction to the perception that the European Court, from the get-go, doesn't have enough legitimacy. It's fragile. The first thing you will hear in debates about Strasbourg is that Strasbourg is international courts, countries may pull out any time, there's pressure on the court, when they don't like the judgments, the court is going too far. So this is part of the debate. So I think it's important to ask the question, why should there be a Strasbourg court? Why should the court have this power to concretize the values of Europe? My own view is that it should have this power, it does have this power as a matter of the rule of law, and I will try to explain why. I want to begin with a very old case. The case is from the 70s, it's really one of the first cases of the court, the case of Tyrer versus the UK. And I want to just read out the facts of this case, just to remind everyone, I'm sure you know the case, but I want to just draw to your intuitions about the nature of human rights and what the court is there to do. 50 years ago, 1972, a boy, 15 years old, called Anthony Tyrer, walked into the local police station in the Isle of Man, accompanied by his father. He was made to take down his trousers, underpants, and bend over a table. 2 policemen held him, and the third one started to administer strokes using a birch rod. The birching was so hard that pieces of the rod fell off. The boy's father could not bear to watch and attacked one of the policemen, trying to stop them. The boy had earlier been caned by his school and then pleaded guilty before a juvenile court for assaulting another pupil. He was sentenced to 3 strokes of birch on the day. Now, the court found a violation of Article 3 in this case, and later, in 1983, in Campbell and Cousins, the court found that any type of corporal punishment in British schools amounts to a violation of the Convention. But I want to ask all of us here what the court would have done if it were to look at consensus in Europe on corporal punishment at the time. It appears uncontroversial to us now that corporal punishment of juveniles is a violation of human rights. But it wasn't at the time, and there was no consensus really about it. And I want to suggest to you that corporal punishment of kids and juveniles was no less a violation in 1972 than it is now. If the court were to look at consensus, it would have reached a different result. And I want to explain now a particular problem we have in democracies, which is at any given time, there will be a lag between what human rights require, how the values we realize are there, what rights protect, and recognition of those rights in domestic legislation. And I think this lag, this discrepancy, so this delay in domestic states recognizing a right is because of endemic defects in the democratic process. And I want to suggest 4 such defects. I should note here, I don't think it's disagreement and not belief in rights that is the problem. I think it's to do with the normal process of elections. So the first problem is that electoral reform, is not easy to do. Even if a country wants to abolish something like corporal punishment, it has to plan it
it has to make it part of the manifesto, it has to get advisors, drafters, and it takes time of a government which has to deal with more imminent issues like the economy and particular societal problems that the people are worried about. So inertia is an endemic factor of reform. And at any given point, you might have a situation where a country would well have adopted a right and recognized it, but they haven't gotten around to it. The second one is more problematic, which is electoral cost. When you make a reform like abolishing corporal punishment, a lot of people would be unhappy because they just use it. And there will be losing of votes. This could be the case even if the majority of people are against it. So for any government, it's easier not to do something than to actually do the reform. They will save themselves some votes. And therefore, they will not have incentives to change it because it will take a brave government to take the decision to lose those votes. Third, and I think this is most important nowadays, many human rights issues that are pressing are not even on the horizon of the national legislature because it affects individuals that are not represented in legislature. So it may affect immigrants, refugees, children, prisoners, people with mental illnesses. These people have no voice, and therefore any human rights that affect them will not become visible to the legislature, such that there will be the appropriate legislation. And finally, what we have as an endemic problem is incentives of legislatures to backslide. In the UK, as you probably be following, the government now is using the so-called Rwanda plan in the most hypocritical way, in my interpretation, just to pander to the votes of their base, in a desperate attempt to present this as lawful, even though it's obvious to anyone who is not legally illiterate that the plan is in violation of international law. Now, if you have enough state backsliding, then consensus also evaporates. There won't be enough agreement. What was agreement one day could become absence of consensus because some states backsliding. So these four endemic problems of the European consensus mean that there will always be this lag between what the human rights values require and what rules you find in legislation, even in the public opinion of the people. Now, I want to ask you this. When it's pretty clear to the court that the values require something and European consensus is lagging, what should the court do? Wait for the consensus to be formed, or lead the way and rule the violation? In my work for 20 years now, I've been saying that the courts should lead the way and rule the violation. And I want to explain very briefly why I think that is the case. In any, I think, democracy, in any setting where a court has to interpret a text, a Bill of Rights, the primary obligation of the court is to give a legal analysis of the issues. Begin with the right at stake, analyze the aim for which it's restricted, analyze proportionality, look at the reasons for which the right is being violated, assess them, and come to a judgment about whether the right has been violated. It's nowhere near written in the Convention that the court should look at what states think the right is or what public opinion thinks the right is. To do so would be to relinquish the court's judgment. A court is there to judge, not to take someone else's judgment about what the right is. For example, public opinion across domestic states or legislation. And I don't think the court, by doing that, goes against the states in any way, because the ultimate value of the court is to be faithful to the rule of law. It's not the court itself that was put there. It was put there by the contracting states. The text of the Convention contains abstract language, which is an invitation to the court to judge what rights people have, not to defer this judgment back to the states or back to public opinions. Now, one example here that I want to give very briefly of how this issue keeps coming back and again to the court is same-sex marriage. Similarly to previous cases, the case I have in mind here is recognition of birth certificates of post-operation transsexuals, where the court took 15 years to find this a violation on the basis that not enough states recognize this is a human rights issue. And it seems to me that reading those judgments, Goodwin judgment, that the court is pretty clear that they think it's a violation. They don't rule it because they're afraid about the backlash from the states. They just want to see enough states getting on board. And it seems to me that there's a problem there, because what the court is really doing is not consensus. It's not whether all 46 states agree. It's whether the majority agree. And it seems to me that looking at the majority raises a number of problems. Is it absolute majority, relative majority of states, the majority of states who have a problem of this human rights nature, the majority of states that have already addressed this in the legislation, because a state may not have any view about this. There may be no relevant legislation about this. Looking at what most states do does not appear to be a legal argument. It's not a legal analysis. It's empirical analysis. It's not legal. And there's another issue, though. If consensus really means majority, it goes against the nature of human rights. It's part of the meaning of a human right that you have it even if the majority thinks you don't. I think that's what it means to have a human right. That is the origin of human rights. It's to protect minorities under persecution in a context where the majority uses legislation and the parliamentary process to legislate against the rights of the minorities. So it seems to me counterintuitive to say that if you have a human right before Strasbourg, it is subject to a proviso, even if it's rebuttable, that enough states, the majority, must agree that you have this right. Now, the issue of whether what I'm saying is totally out of line with the actual practice of the court, I want to invite you to read all the cases where the court uses consensus, and I think you're going to find something very interesting, that the court proceeds with a thorough analysis of the aim, proportionality, necessary in a democratic society, and then, after having done this legal analysis, they will throw in consensus to the mix, I think for appearance, for telling the states, look, this is not just us doing this is what you are doing as well, so we're just going along. It performs a function of rhetorical device, that we're not out there on a limb. I wonder whether this is necessary, because at the end of the day, a court is judged by the quality of the reasoning, not by the quality of the rhetorical devices it uses. This is not to say that comparative law is not important. A court should look at what legislation is in different parts of the world, but it's to inform the judgment, not to dictate it or determine it. If the court is convinced something like same-sex marriage is a human right under this HR, then why should it wait? Imagine if Tyler, the 15-year-old boy, had to wait 10 years until corporal punishment had been fully abolished in most states. Wouldn't that be an arbitrary reason to deny an applicant a remedy? I'm just asking, this is not a rhetorical question, I'm asking, can a court justify to itself delaying justice for 10 years on the basis that not enough states have legislated? And the complication for me here is that the absence of legislation could be purely accidental for the factors I've mentioned. Parliament never gets around to it, there was electoral cost, it takes time, and so on. So I'm really worried about using consensus in that way. And I actually think the court pays lip service to the idea. I know people are uneasy about this claim, and the question I get always in this respect is, okay, if not consensus, then what is the court going to turn to decide the case? And I think here is a crucial part of the discussion, and I'm going to finish with this. There is a worry about the determinacy and objectivity of human rights. It's a widespread worry. Many people are skeptics about human rights. You might say, well, I don't know what to decide. Should euthanasia be a human right at this HR? Should same-sex marriage? Should abortion? It's really difficult. States disagree. How am I supposed to go about? Maybe consensus is an answer to the problem of a lack of determinacy. And I want to say to this argument something which seems to me obvious. If you take the most fundamental human rights, saying that they are rights doesn't make them rights. Even if we all here agree that torture is a good thing, it wouldn't make torture a good thing. So saying so doesn't make it so. And the objectivity of human rights has to be taken for granted. And it's to that nature of the right that the court turns. And in my opinion, the court has done a really good job in this. And consensus is not really part of the tools that the court really uses. So just to summarize my arguments today, consensus is typically thought to be a solution to a problem. The problem is lack of legitimacy to concretize the values. And the court, by tracking consensus, is trying to refer back to the states from which people might think its legitimacy is derived. I think the real legitimacy of the court derives from the rule of law and the importance of human rights. And if you have that in mind, then consensus kind of falls out of the window. So instead, concluding, I want to propose the following reconceptualization of consensus. I think we will all be better off talking not about consensus, but about common values. I think that would be more productive. Thank you very much.
Thank you very much, Professor Letsos. Very interesting and thought-provoking another presentation. And of course, I'm standing here and I want to agree with George. I'm really wanting to agree. But I have a few difficulties with that, unfortunately, because first we disagree about values, and this is a very legitimate disagreement. The second problem that I have, even if we agree on some values, the translation into the solution to the court's case might be a very difficult thing to do. And I think consensus really helps us in doing that. I remember I did interviews for my first book, and I always remember one judge telling me that, I asked them if they think that European consensus actually can persuade them. And this judge said, well, if I have a very strong personal conviction on a particular point, no consensus would ever persuade me. But if I don't have any strong conviction on that point, consensus can really inform my decision. So I think that is a very interesting. I don't think that that is the correct approach to European consensus, but at least it's one of approaches. Anyways, I hope that we will have time to discuss this more later on. The last, but not the least, of course, the next speaker on my list is Elina Vitola, Deputy Agent of the Government before the European Court of Human Rights. Madam Vitola graduated from University of Latvia and Riga Graduate School of Law. And she has been working with the Ministry of Foreign Affairs since 2018, I want to say. In 2020, Madam Vitola became the head of Office of the Agent and then Deputy Agent of the Government. I always like to spice up my, as you know, my presentation of participants. And I did a little bit of digging. I wanted to check how successful Madam Vitola was in her work in front of the European Court of Human Rights, and that's the statistics that I got. There were only 23 judgments delivered against Latvia since February 2018, when Madam Vitola has taken her position. Out of these 23, the court found violation only in 14 cases, which I think is an excellent result. So since Madam Vitola has taken her position, Latvia loses on average 2 cases per year, which is very, very, very low number of cases, I have to say. Please, I am delighted to welcome Madam Vitola, please.
Thank you for this wonderful introduction, although the statistics are not entirely attributable to me. Ladies and gentlemen, from the outset, I'd like to thank the organizers of this conference, and especially for bringing into limelight the constitutional values and constitutional identities in the context of a European consensus. Today, when Europe is a battlefield not only in its primary sense, but to some extent a battlefield of values, I think it's very important to discuss these issues for us to come to a consensus on our way forward. Being the last speaker on this panel, and actually all the panels today, I had a temptation to look at both notions that we are discussing here today together. And I think from what Professor Letts has just told us, I think to some extent I will just follow up on him. But let's see. So, namely, what is the relationship between constitutional identity that represents the values of each particular member state to the Council of Europe, and the European consensus, which stands for the shared values of those same states? I think there should be no surprise that Riga is the city that hosts this conference, considering that the latest case law from the Strasbourg court, and I will further refer to this court as the court, because the court's case law in Latvian cases has done just that. It has balanced the European consensus against the constitutional identity of Latvia. So, although not all cases that I will touch upon today have directly referred to the European consensus in interpreting the obligations of states under the Convention or the state's margin of appreciation in fulfilling these obligations, the cases of Savitskis and others, Valjulina and others, and Djibouti and others are among just a handful of cases where the specific concept of constitutional identity has been absorbed in the court's assessment when examining questions with both a clear European consensus and when there is none. That said, of course, and I do acknowledge that we have some information about this in our first panel today, but that said, the court has previously in its case law referred to notions such as constitutional values, fundamental principles of states, and, of course, constitutional importance. Among others, when talking about the state's national flag, territory, language, respect for human dignity, or the principle of secularism. But before I look at the cases I mentioned before, from a general point of view, I can just thank the previous speakers who have elegantly described how the court uses the European consensus as an interpretative tool, as a tool to legitimize its findings, or perhaps not, and as a tool for making up and formulating the standards under the Convention. From what has been said, one thing is clear. European consensus is one of the elements that lie at the heart of the evolutive living instrument doctrine. As expressed for the first time in the Tyre versus the United Kingdom, the Convention is a living instrument which must be interpreted in the light of present-day conditions, and the court cannot but be influenced by the developments and commonly accepted standards in the member states of the Council of Europe. However, this finding as such does not refer to the practice or legislative acts of states in their domestic legal systems alone. Neither does the court's subsequent practice confirm that the consensus would be built solely on the practice of states. Instead, the court refers to commonly accepted standards. This, by its very nature, should be perceived as a wider concept that requires more than a comparative analysis of the domestic legal framework in an undefined number of states that would somehow consolidate a consensus. Although without a doubt, both the parties to the proceedings and the court use a comparative analysis as one of the ways to find a particular standard to exist, in the most sensitive cases, which I have in mind, a significant role in the court's jurisprudence is also played by the evolving standards in the international fora, the political decisions and declarations at the Council of Europe level, views of other international bodies, but most importantly, by the underlying values of the Convention. As recently reiterated in the ML and Poland, a judgment which has not yet entered into force, the rule of law is inherent in all the articles of the Convention, and the whole Convention draws its inspiration from that principle. The provisions of the Convention must be interpreted in the light of the preamble to the Convention, which in its relevant part declares the rule of law to be part of the common heritage of the contracting states. One of the somewhat recent examples of the methods used by the Court in establishing a consensus and underlining in that assessment the fundamental importance of the values protected by the Convention system can be seen in the already mentioned Fedotova and others. In particular, the Grand Chamber noted that by the time of the examination of that case, 30 states had recognized the obligation to provide a legal framework allowing same-sex couples to be granted adequate recognition and protection of their relationship. This led the Court to establish a clear, ongoing trend. And do not get me wrong, I do not attempt to distinguish between an ongoing trend and a European consensus. However, the Court did not stop at the point of a comparative analysis of the practice in states. It went on to note other developments that could consolidate this trend. In particular, it referred to the findings of the United Nations and the Council of Europe High Commissioner for Human Rights, the United Nations Committee on Economic, Social and Cultural Rights, the Committee of Ministers and the PACE recommendations, the Charter of Fundamental Rights and the case law of the Court of Justice of the European Union, and even the practice of the Inter-American Court of Human Rights. Ultimately finding that there was a sufficient consensus among the states parties to recognize and protect the relationship of same-sex couples, the Court also linked this finding to the need to safeguard the values of the democratic society promoted by the Convention, foremost among which are pluralism, tolerance, and broad-mindedness, because, as the Court put it, any interpretation of the rights and freedoms guaranteed has to be consistent with the general spirit of the Convention, an instrument designed to maintain and promote ideals and values of a democratic society. Moreover, this finding also warranted the Court's rejection of Russia's arguments that feelings of the majority of the Russian population and the perceived need to protect minors from promotion of homosexuality justified its failure to ensure recognition of the rights of same-sex couples. Against this background, it seems rather obvious that whenever we talk about European consensus in sensitive cases, it almost always comes down to the fundamental values that the Convention strives to protect. Regardless of whether the consensus follows directly from the measures already adopted at the domestic level and their comparative analysis, or from the values generally protected by the Convention, they always come under this larger umbrella of shared values. On the other hand, it also follows from the Court's case law that even where the practice of states is homogeneous, which would warrant a conclusion that a consensus exists and the margin of appreciation accordingly is narrow, the Court may still, based on the finding that the case concerns an indisputably sensitive area of law or interests of the state, conclude that the consensus leaves space for the values underpinning the domestic legal system to enter the assessment of the state's margin of appreciation. A case in point is A, B, and C against Ireland. Briefly, the proceedings were brought before the Court by 3 women who argued that the impossibility to obtain an abortion in Ireland, except for cases that threatened the expectant mother's life, had been in violation of their right to respect for their private life. The Court noted the sensitivity of the moral and ethical issues raised by the question of abortion and found that a broad margin of appreciation should be accorded to the Irish state in determining the question of whether a fair balance has been struck. At the same time, the Court also found that, at the time Ireland was the only state party to the convention which allowed abortion solely where there was a risk to the life of the expectant mother. Yet, this did not lead the court to conclude that the margin of appreciation for the Irish state should be narrowed down. And the practice in Latvian cases shows that the same approach, exceptionally, may be applied vice versa. That is, to expand the narrow margin of appreciation that exists based on a common standard among the state's parties if it does not contradict the fundamental values of the Convention. I think it goes without saying that whenever an aspect of the state's constitutional identity comes into play in a given case, it undoubtedly touches upon a delicate issue. This also follows from the court's existing case law, for example, the case of Mensen versus Latvia, and has been recognized by the president of the court during her speech in Riga last September. In such cases, the court has to be mindful of this sensitivity, and the states, in turn, must trust the court that it will be mindful of it. This is precisely what happened in Savitskis, Vaļuļina, and Djibouti. The court was mindful and consolidated its methodology in respecting the constitutional identity of a state in the determination of the state's margin of appreciation. In the case of Savitskis and others, the applicants claimed that they had suffered discrimination with respect to their right to peaceful enjoyment of possessions as protected by Article 1 of Protocol No. 1 to the Convention on account of their status as Latvian non-citizens. The Grand Chamber, by a majority of 10-7, overturned its previous finding in Andreeva and found that there had been no violation of the applicant's rights. In particular, on the one hand, the court reiterated its well-established case law that where nationality, or rather absence of it, is the sole criterion for the distinction, very weighty reasons must be adduced to justify a difference in treatment. Now, although the judgment itself does not mention consensus regarding this, it is clear that the determination of the margin of appreciation was first based on the values-oriented European consensus, which required those very weighty reasons and accordingly afforded a very narrow margin of appreciation to states. On the other hand, the court took note that the doctrine of state continuity, which was at the core of that case, formed the constitutional foundation of Latvia following the restoration of its independence after 50 years of occupation by the USSR. Having recognized that the legitimate aim for the difference in treatment of non-citizens was based on an aspect of the constitutional identity of Latvia, the court decided to examine the very weighty reasons requirement against this background of an intrinsically sensitive legitimate aim, the constitutional identity of Latvia, and the historical background of the case. Thus, the margin of appreciation afforded to Latvia was wider. Similarly, but perhaps from the first glance less evidently, the constitutional identity aspect had an effect in the Vaļuļina and Djibouti judgments, which entered into force just recently. In those cases, the court examined complaints by parents and their children regarding the increase of the Latvian language as the language of instruction in education in public and private schools in Latvia. As a result of this increase, the proportion of Russian, which was the language used by the applicants and their children in education, was reduced. Before the court, the applicants claimed that the measures had been discriminatory against them because before their adoption, the applicants had obtained education in Russian, their mother tongue, in a larger proportion. However, before turning to the alleged discrimination, the court examined whether there was a consensus that would recognize a right to obtain education in a language other than the official language of the state. The court noted that the principle of mother tongue instruction has been recommended by some international bodies. However, it did not represent a common European consensus in the field of education. Importantly, in its conclusion, the court also relied on the government's argument that only in a handful of states such a right had been provided, and the assessment of the Constitutional Court of Latvia, finding that there was no consensus among the states parties, including under the other relevant international instruments in this field. This finding accordingly led the court to conclude that not only Article 2 of Protocol number 1 to the Convention did not guarantee a right for minorities to receive education in a language of their choice, but also that the states' generally wide margin of appreciation in organizing their educational systems was particularly wide as regards the language of instruction. Although not expressly, the fact that the Latvian language is an aspect of Latvia's constitutional identity, as acknowledged by the court in its previous case law, came into play at every stage of the case. First, it was recognized as a legitimate aim, inter alia referencing the Court of Justice of the European Union, Insulevich and others. Further, in its proportionality analysis, the court acknowledged that Latvia had to take steps to correct factual inequalities so that Latvian-speaking individuals could regain their right to use Latvian in all spheres of daily life, including their right to education in the official language of the state. This conclusion did not hinge on the generally wide margin of appreciation of states when it comes to organizing their educational systems alone. Seeing that the judgments in Valullina and Djibouti often circle back to the findings of the Constitutional Court, which in turn assessed the relationship of the Latvian language as a constitutional value and the international consensus at length, although not explicitly, the judgments as such embody the interaction between European consensus and the constitutional identity of Latvia. From what I have said, it seems to me that European consensus, which is built on the basis of shared values of the states parties to the Convention, and the constitutional identity as a value of a particular state, are not something that should clash. They are, in principle, two sides of the same coin. And in the court's case law, they should create a synergy. Mutual respect for both sets of values that make up the Convention system, one being based on the other, is crucial to ensure a long-standing understanding of the system and the way forward. At the same time, this means that there is a delicate line to be drawn. It has been noted that sometimes states invoke constitutional identities to circumvent the fundamentals of the Convention system that are based on the shared values of states. So, one might ask who and how is the first to draw this delicate line? In my view, the answer lies in another fundamental principle that underpins the Convention system, the principle of subsidiarity, which requires also a substantive dialogue between different courts, which is demonstrated by Savitskis, Valullina, and Djibouti. The Strasbourg Court respected the findings of the Constitutional Court of Latvia, where the latter had explained in detail Latvia's constitutional identity and the need to protect the identity under the umbrella values of the Convention system. Only where this assessment is based on the pillars of democracy, the rule of law, pluralism, respect for human dignity, will it find its place in the broader European consensus. To conclude, in my day-to-day activities, I'm usually asked to provide answers to questions. But in my personal capacity, I find myself more often than not asking questions. And I think it's a sign of a healthy mind. So to conclude, perhaps it is worth asking whether there might be an ongoing trend or a European consensus that when a constitutional identity of a state enters into play in a given case, there might be a wider margin of appreciation afforded to it, provided that in the interpretation and application of the many facets of the constitutional identity, the courts and domestic authorities take into account those umbrella values that the Convention protects. I thank you.
Thank you very much. I have to say that it was an incredibly easy panel to moderate because everyone was on time and very interesting and exciting presentations. We have about half an hour for questions and answers, as far as I understand. So if you could press the buttons, I can see that there are already the whole list. So I was going to give some preliminary thoughts, but apparently I will have no time. And I have to say that this old technology is very exciting, but it is very weird to see your face right in front of you on the screen. But anyways, just before we go to, and while people pressing the buttons, I wanted to reflect a little bit on what the presentation was, and I think that ABC is a very controversial case in terms of implementation of European consensus, which I thought it was a slight, as a challenge. Let me be as diplomatic as possible. It was very challenging judgment to comment, to be honest with you, and I thought that it was the only judgment where internal consensus trumped European consensus. And here we have quite a few problems, because it is very difficult to have very scientific methods of identification internal consensus. On the other cases, as I said, I think that European consensus can be a rebuttable presumption, and references to history can be one of the reasons where the states try to rebut European consensus, which is very closely connected to constitutional identity to some extent. And in the past, the court was quite critical about these arguments. The case that comes to mind is Tanasi versus Moldova, where the facts, I'm not going to repeat the case, but in that case, the government argued that the fact that dual nationals cannot run for parliamentary elections is somewhat part of historical development of the Republic of Moldova. Anyways, without any further delay, I'm delighted to pass the floor to former judge of the European Court of Human Rights, Judge Alvina Gulumean.
Thank you. Honorable President of the Constitutional Court of Latvia, dear participants. First of all, let me thank the Constitutional Court of Latvia for inviting me to this truly important and timely conference. I would also like to take this opportunity to warmly congratulate my Latvian friends on a memorable anniversary, Latvia's accession to the European Union. Considering Latvian cases in the European Court of Human Rights, I had the opportunity to see how important this membership was for Latvia, how it contributed to the strengthening democracy in the Latvia, how greater protection of human rights, even ensuring the security of the country, and why not liberation from the bonds of the Soviet past, that past to which some autocrats of the post-Soviet space are trying to return their countries. My country, Armenia, is not a member of the European Union, but being a member of the Council of Europe, we fully share all European values, which I defended in the European Court of Human Rights for about 12 years, and for the same amount of the time in the Constitutional Court of the Republic of Armenia. And based on my experience of working in both courts, I can say that both courts, when it comes to human rights and fundamental freedoms, each work within their competence over the common task of protecting them and creating conditions for achieving the common values and goals of a democratic society. And my conclusion was that the constitutional identity does not in any way cancel general principles and common values. In my view, there needs to be a common understanding consensus, if you wish, of how true constitutional identities and true common European values can be distinguished from false identities and values. As for the collisions, in my opinion, the most dangerous and actual and not the perceived collision is the collision between the declared values and how these values are protected, whether they protected at all or not. It was this collision that led us to today's catastrophe on the European continent, to the biggest and bloodiest war since World War II, the war in Ukraine. Against the backdrop of current geopolitical events and at least attempted genocide against part of my people living in Nagorno-Karabakh, their blockade for over 9 months, and the subsequent ethnic cleansing and deportation of approximately 140,000 Armenians from their homeland, where they have lived for millennia, I often ask myself the question, what are the real values? Have we managed to defend them, and how sincere are we in this matter? It is said that the Council of Europe rests on 3 pillars: democracy, the rule of law, and human rights. But is it democratic for one person or one family to rule over 20 years in a member state of the Council of Europe, exercise a dictator who still holds dozens of Armenians prisoners, took hostage, and actually tortures in prisons the democratically elected leaders of Karabakh only because they wanted a peaceful, democratic, and free future for their people. In fact, Azerbaijanis attacks in 2020 on Nagorno-Karabakh and subsequently on Armenia itself did not, in fact, receive proper reaction from the world, especially from actors that share the values we are talking about today. And this was essentially the first toll of bell. At the beginning of the 21st century, this call, namely the brutal and unpunished use of force in violation of international law, was noticed only by one leader, namely the President of Russia, who took this silence of the world as a signal to action and unleashed the same aggression against the Ukraine. I apologize for expressing my pain here, but today we are talking about shared values, and perhaps this would not have to be said today if the reaction of Council of Europe and European Union had been more appropriate to the tragedy that occurred in the Nagorno-Karabakh, if the leaders of some states aspiring to democracy had not congratulated Azerbaijan on the so-called restoration of its perceived territorial integrity, the integrity of territory that Stalin, the bloodiest dictator of the history, outlined according to the principle of divide and conquer. And I don't just ask the question, what is true value? Judging by where our world is heading, we will increasingly have to face this choice. Democracy, human rights, self-determination, or the perceived territorial integrity of empires, small or large. Do we have consensus on this issue? Thank you for
Thank you very much, Judge Gulumian. I think it was more comment rather than question. I don't know if colleagues want to comment on that, but thank you very much. We'll move to the next speaker, and the next speaker is Karina Palkova.
Thank you very much. I'm here. It's again me. Thank you. First of all, thank you so much for this exciting panel. And you spoke about the synergy. You spoke about the subsidiarity. Especially Elin spoke about the dialogue between the courts. So could you please tell me in practice, how do you raise this dialogue between the courts? From the practical perspective, of course, more. As a professors, as a professionals, how do you evaluate this dialogue between the courts?
Thank you very much for the question. I think Madam Vitala will, it was directed to you first, please. Is it working?
Is it on?
Yeah.
Okay. Thank you for the question. I'm not entirely sure that it is only to me. Maybe you have some ideas because you are...
You just start, you go ahead.
But I will start. How do I evaluate? Well, in Latvian cases, I evaluated very good. But I mean, from a general perspective, it depends from case to case. And from the cases I mentioned today in my speech, you can see that the Strasbourg Court and the Constitutional Court of Latvia are in a dialogue. In Vaļuļina and Djibouti, there was a trialogue even, because, as I mentioned, the court referred to the Court of Justice of the European Union in the Tsilevich and others in establishing the legitimate aim. So, being an expert rather on the Strasbourg Court side, I'd say that the Strasbourg Court is very efficient in consolidating the very domestic and supranational institutions and values. So that would be my general comment. Thank you.
Thank you. Professor Latsis?
Is this... It's on? Okay. Yes, so I just want to draw a distinction between dialogue between courts, or even more so between courts and legislatures, as an exercise in discussion about what the legal rights and duties are, where each party to the dialogue is trying to enrich their own understanding of the legal principles at issue. And I think that's essential. But that's different from using dialogue as a way to decide a case, which is another metaphor often used about courts. And whenever dialogue appears in that stage of a court deciding a case, it reminds me of my own experience taking a driving license test, where when I took it, it had a diagram, multiple choice diagram of a junction, and it asked which car should have priority. And you were supposed to know which car of the four. And there were the 4 cars in the junction, and then there was always a 5th choice. The choice was no car has priority, the driver should engage in dialogue. And my driving instructor told me, if you are in doubt about which car has priority, never go for the 5th option. It's always wrong. And the point being that at the end of the day, someone has priority, someone has a right or a duty, someone has a claim before a court. And dialogue, of course, is a way to enrich your understanding, but when you decide that issue, dialogue is not really an issue there. You have to exercise the judgment.
Thank you very much. If I could just a couple of words add to that. I personally think that terminology of dialogue is misleading, because obviously courts don't come to each other and engage in lovely discussion over a glass of wine or something like that. Although sometimes they do. Yes, I agree. I think that it's better conceptualized in the form of feedback loops. So basically, and feedback loops can be formal and informal. And wine and conferences, this is informal feedback loop. Formal feedback loops can be created preemptively, namely before the judgment is delivered or post factum. Before the judgment is delivered, we have examples like Al-Kawadi and Tahiri Horncastle discussion between the Supreme Court of the UK and the European Convention, the European Court of Human Rights. New preemptive feedback loops can be created through Protocol 16 engagement with this apex court. Post factum feedback loop can be in a sense of, well, sometimes it's rather unpleasant for the European Court of Human Rights when the states resisting or trying to explain why they don't want to implement a particular judgment, or a particular issue goes back and forth from the European Court of Human Rights, and the standards actually crystallizes in this exchange. So I think that feedback loops is a better way of conceptualizing dialogue, because dialogue it's a bit misleading, and it's not only with judges and judge courts, but like also with other authorities, like Ministry of Foreign Affairs, for example. It can be the court can also very legitimately, I think, engage in a The next on my list is Judge Danuta Iceni.
Thank you very much.
Oh, it just worked. Perfect.
Thank you very much. So I think, thank you very much for your brilliant presentations. I really liked very much these discussions about European consensus and how we look at it. So then, first of all, I think you can take the European consensus as a way for the European Court of Human Rights to negate its responsibility under the Convention, because we have a clear obligation of the Court under Articles 19 and 32 of the Convention. So, and of course, it's very easy to the European Court to say, okay, in this case, we do not have European consensus, we can just wash our hands in admissible case. And of course, maybe this point of view is not very correct. Another way to look at the European consensus is just to raise a question whether this European consensus or this notion is needed at all. And I have a bit specific opinion on this issue, because in my opinion, in fundamental or absolute rights cases, in my opinion, European Court of Human Rights cannot use at all the European consensus, and therefore here I would not agree with George's question concerning Tyrer case. Tyrer case, of course, touches the fundamental right. It's like, even at these days, it would be even not degrading treatment. In my opinion, this is clear inhuman treatment, maybe not torture. So, and when we have fundamental rights under the Convention, in principle, in my opinion, you cannot even go to the European consensus and to rely on this issue. So Article 5 and 6, for me, it would be difficult to imagine also application of European consensus. Maybe it could be some very sensible specific issues. And then we come to the fundamental freedoms, which of course is very often when the European consensus is involved. But here, in principle, again, we have the so-called classical test, yes, of three. We have legitimacy, we have necessity and proportionality aspect. So my idea is that relying on the classical test, in principle, you can resolve the case. So this is how I see the European consensus, but okay, I don't want to go into the detail. But I would like just to ask maybe your opinion, Konstantin and maybe George, because you are professors from this field. I have many doubts concerning the case Fedotova and others versus Russia. Okay? I think we all know the European Court of Human Rights found a violation of Article 8, saying that the state should give une reconnaissance et une protection juridique adéquate pour the same-sex couples. But where is the problem in this case? This case was submitted to the European Court of Human Rights in 2014, okay? The chamber judgment was given in 2021. Okay, Russia still was the state party to the convention and member state of the Council of Europe. Now, the case was sent before the Grand Chamber. The Grand Chamber adopted the judgment on 17th January 2023, when Russia was not anymore the state party to the convention and the member state of the Council of Europe. And here I really see the problem, because why this case now is so important, relying on the European consensus, of course. European Court of Human Rights invited Russia and also some other states of the Council of Europe to adopt this form of protection juridique adéquate for the same-sex couples, and cases are already coming before the ordinary courts. Even in Lithuania, we have already the case pending before the ordinary courts when the same-sex couples are asking for the marriage institute and so on, and asking ordinary courts to resolve this issue. Of course, I cannot comment anything more, because now I'm judge of ordinary court, not anymore the constitutional court. But what I wanted to say, I was a judge of the European Court of Human Rights, and of course I totally agree with Elina when you said, but the problem is that when we speak on theoretical principles and all theoretical aspects, everything is very nicely and very okay. But the problem is, you are government agent, yeah? You know quite well. The problem is when this judgment comes before the domestic domestic authorities. And imagine I was a government agent going to my authorities and saying we have to implement this judgment because the European Court of Human Rights decided like this. I think this is the problem that all international courts, Court of Justice, European Court, even Constitutional Court, we have to be very careful in reality in balancing all these our common European issues involved in adopting judgments which are executable, because this is the most important aspect. If you adopt a very nice judgment, as this Fedotov and others versus Russia, which in principle Russia would never execute, as you understand yourself now, and there are from such judgment which is adopted against the state, which is not anymore the state party to the convention, but there are some obligations coming to another state parties of the convention. I really doubt that this European consensus was properly used in the case. Thank you very much.
Thank you very much, Judge Yuchena. Can I suggest that we take 2 more questions in the interest of time and then briefly respond to all of them? I would like to invite Leila Medina to speak, please.
Yeah, thank you for giving me the floor. And being myself less impacted by the Strasbourg Court, my question is more related to the European Union's law, and thus directed more to my dear colleague, Mr. Spooner, and maybe also to the Judge Kuch to see it from the national court's perspective. And I was picking up on the thesis that within the Union's legal order, the treaty could be seen as a consensus between European member states, and then if that is the premise, one could say that the secondary legislation is kind of concretization of that consensus, especially when we take into account the legislative process within the European Union, where every single directive or regulation, it is a process of the Council, which is member states, and the Parliament, which are the elected parliamentarians. And it is in that process the secondary legislation is adopted. And on the other hand, if we take into account that, in my view, the consensus is something which is changing all the time, because the times are changing, so you can never say that we know what is European consensus. We can just take a snapshot. That at this moment in this area, one might think that this is what this consensus look like. And from there, my question, could it be seen that the preliminary reference procedure where national courts are asking the questions to the European Court of Justice is in a way reflection which are the areas where there is not really consensus yet found, because the national courts are still in doubt. And then there, the European Court of Justice is in a way as a forum where you can try to find that consensus, because it's, especially when it comes to sensitive cases, that is the formation of more than 3 or 5, it's usually the grand chamber cases, where you have also from judges the input from different, with their different backgrounds. And that is a way, in a way, a development, because then the judgments are taken on board by the legislator, by the Commission, to go yet in the legislative process to search for that consensus. Would that also not be kind of a way to show why the judges are needed to sometimes answer what the law is, to make that snapshot of the moment?
Thank you very much. And if I can be a little bit rude and ask you to ask a question as quickly as possible, I pass the floor to Professor Huber.
I didn't want to ask a question, but I wanted to contradict you as far as...
Spend as much time as you want.
As far as you said that dialogue doesn't exist, it's rather feedback rules. They are, as far as formal procedures are concerned, this is evident that there's Article 267, and you can also describe the opinions of the Advocate General as a sort of dialogue, because he deals, or she deals, with the legal systems of the member states. But besides that, there is such a variety of also effective dialogues, not concerning the pending case, but the line of jurisprudence. And if you're interested, the Austrian Constitutional Court has published 3 volumes on the dialogue within the European legal area in 2014, where this is all described. It ranks from citing each other in the decisions, to bilateral meetings, to meetings of the German-speaking constitutional courts, and also informal telephone calls between constitutional courts. I would have the possibility to tell you a very interesting cooperation we had with Vienna, but I think my time is not long enough to tell you the whole story, but we could do this in the break. Thank you.
Thank you very much. I'll get back to this point very briefly at the end, but if I probably there is another one. I don't think that. Okay, very briefly, 2 seconds. Okay, Galina Yarovska, please.
Yes, I would like to ask you to hear me, and on behalf of judges of Constitutional Court of Ukraine, I have pleasure and honor to extend my congratulations with occasion of the 20th anniversary of the membership of the Republic Latvia in the European Union. And it is gratifying that the Constitutional Court of the Republic Latvia became an esteemed partner of the Constitutional Court of Ukraine in new project of the Council of Europe, support to development of constitutional justice in Ukraine. And all judges greatly appreciated this partnership. In the context of today's topic of this international conference, we all strongly believe that the experience of all constitutional courts and especially Constitutional Court of the Republic Latvia will help to learn Ukrainian court how to implement European values in domestic constitutional adjudication. And I ask everyone, remember please, that now Ukrainians are defending European values and national identity with their lives at the front. Thank you.
Thank you very much. That is very important. I'm glad that I allowed this comment. I know that we are already 1 minute into Judge Zimilis and Professor Paparinsky's territory, but I will nevertheless, I hope that I will be forgiven for this. I will give a brief floor to all our speakers for quick concluding remarks, starting probably the way we were speaking from Judge Kuch, please.
So can you hear? Okay, it works. Just responding to Lailas Medina's question, I would, just to be brief, I would agree if we talk about on a general level, then the states agreed on these treaties. But of course, when we start to conceptualize, and I remember with Peter Huber, we already had discussion when he came to our court, for example, about Article 19 and Polish cases, whether when you go to interpretation, whether the Luxembourg court had the competence under Article 19 to go so far. So that's where I think the differences start. So in general level, I would agree, but otherwise I would come to the same conclusion. But of course, Latvia, our constitutional court has been very open. Just to be brief, we have asked, I think, 8 or 9 preliminary questions to, and also our cooperation has been, I would say, so far very positive. I would mention, to add to Elina's about Strasbourg, to mention Celevich case in Luxembourg court, where I would say it was a very good dialogue between us. But there were other countries which were not so successful. Just go back very back. Meloni case, very old one, very much discussed, and it had some, I think, impact on a Spanish cooperation with Luxembourg courts. And if I can tell from my own point of view, not as a judge, but as a citizen, just to respond to the first question as regards Russian Federation aggression. I think we waited much too long. There was invasion in Georgia, there was Crimea, there was, I think, Navalny judgment and the oppression of the opposition. I mean, I think we waited much too long. And unfortunately, I remember just a few days we were with all this in Venice Commission after it happened, and there were, luckily, not a majority. A few colleagues who said, no, we are not a political body, we shouldn't adopt this, any kind of statement. But majority was, and there was a statement by Venice Commission, but the views on this issue are different, and so. But I'll stop here. Thanks.
Thank you. Thank you. Please.
Thank you very much. I got one question from Laila, and I will try to be extremely brief. You're absolutely right that in preliminary rulings procedure, we can learn about common understanding on certain values from national courts. Of course, to the extent we are bound to create common interpretation of certain values, and that's the role of the court if something was harmonized. Then, yes, your first remark, definitely, it was easier, I mean, the member states agreed on certain values in the treaties, but it was easier to agree on the treaties when the European integration was restricted to internal market and economy. Once we entered into very sensitive areas like cooperation in civil and commercial matters, asylum policy, fundamental rights, then obviously this consensus became much more difficult. And to your third remark, yes, the division between the role of the legislator and the courts, and this is to some extent what Professor Hübbe said this morning. With the Union, we have a very specific problem, which is, first of all, very often, and I'm saying this as someone who participated in legislative procedure in the Union, when member states cannot get a compromise, they deliberately draft the legislation in such a way that they give more authority for the court or more competence for the court to decide. We cannot agree, so let's put a very vague, very blurred provision, and we leave it to the Court of Justice to provide the final interpretation. And secondly, the specificity of the Union results also from the fact that if we compare the Court of Justice to Constitutional Court of the member states, national legislator can always react very quickly. So if you in Karlsruhe or wherever decide something, the legislator can respond to your decisions. Whereas the Court of Justice is confronted with let's say a lacuna in the legislation, if you would say let's leave it for the legislator, EU legislator to decide, it would take at least 2 years. Sometimes maybe for pragmatic reasons, we are rather encouraged to say something in order to be, let's say, liberated from lengthy and complicated discussion on the level in the EU legislator, because the functioning of the EU legislator is extremely complex. Thank you very much.
Thank you very much. Professor Letsis.
Thank you. Just on the point about the distinction between absolute rights or Article 4 and 5 and the qualified rights, I would think that the reason you gave for why consensus shouldn't play a role in the former also applies in the latter. It's no less of a violation of human rights if there's a manifestly disproportionate discriminatory interference with Article 8. For example, the famous Max case of discriminating against children born outside of marriage. The court could have looked at consensus, it tried to do, and it talked about emerging consensus. But to me, we have to be clear, the court is not really looking at what all states do. Because if the standard was what all states do, the convention would become obsolete. States already do it. So the discussion starts happening, do enough states do it? And then it seems to me that does not matter if the court is convinced that it's disproportionate. The analysis of the court is proportionality, legitimate aim. So if there's a violation there, but only 10 states of the 46 have a law, should that be stand in the way? And I think the same argument you gave very, very elaborately about torture and human treatment, in my view, applies when the issue is very clear that it's discrimination, for example. It affects no less the lives of people who are discriminated than those who are treated inhumanely in an integrated manner.
Thank you very much. Madam Vittel.
I don't think I was asked a question in the last session, but I caught the question about Russia being excluded from the Council of Europe and the judgment of Fedotova being delivered afterwards and the execution of that judgment. I myself work as a government representative in execution and also represent Latvia in the process of the common supervision. So if you look at Fedotova, following Fedotova, there were many other cases where the court found the same thing. Irrespective of it would have been Russia or another state, the consensus is there and the obligation is there. It doesn't matter whether Russia was expelled from the organization. As for the execution of judgments, I think it is clear that all states have had difficult judgments to execute. Lithuania, for example, has to have amended its constitution for the execution of the court's judgment, and it has done so successfully. And so I think the states have subscribed under the values that are protected under the convention. So even if a judgment is difficult to execute, those values require that the execution takes place. Of course, there are mechanisms of Article 46, 3, 4, but generally speaking, yes, those shouldn't be the primary goal to implement them. Thanks.
Thank you very much. I'm not hiding from two questions that were directed to me, but I'm mindful of time, and I'm hoping that we can pick up on Fedotova and feedback loops / dialogue during the break. On that moment, we have taken 10 minutes of Judge Zimilis and Professor Pafarinsky's time. I cannot abuse their kindness any longer, and I would like to thank the panelists, thank the audience, and pass the floor to the next panel. Thank you very much.
So, dear colleagues, in order to maintain high standards of conferences organized by the constitutional courts across Europe, as well in Latvia's case, we decided to include in programs such a point as future outlook and challenges. And when we did it, our team faced with another challenge. Who would handle with such a challenging topic? And then we found out, in my opinion, brilliant characteristic. Judge of the Court of Justice of the European Union. She was a judge and the president of Chamber at the European Court of Human Rights. Also was a judge and the president of the Constitutional Court of Latvia. It means the person can analyze the issues raised at this conference as an expert, both the National Constitutional Court and 2 European courts. That's why we decided, in a context of upcoming Eurovision, that not just 10 points, but all 12 points goes to our esteemed colleagues Ineta Ziemele. Ineta, we are really delighted that you have agreed to give your insight slightly to the future about these 2 vague concepts. Please, take the floor.
Good afternoon, dear colleagues, ladies and gentlemen. I was almost coming with the ball to predict the future, but I will try not to do it. Now, I would like to once again congratulate actually the 10 member states of the Union who joined the Union 20 years ago, and it's not only Latvia, but the other 9, and many of you are here. And I have been greatly helped by First Advocate General Spuna. I will not have to focus solely on the European Union and the particularities of the EU legal system. Indeed, I have the opportunity to share with you, in fact, some of my reflections, thinking about the present, the past, and the future, that are aimed at bringing the 3 legal orders that all of you present, in one way or the other, represent today here. And I would also like to thank the Constitutional Court of Latvia for this fascinating day of intellectual gymnastics. I do think that we all realize that oftentimes within the span of 2 minutes we have been jumping from one perspective to another perspective to the third perspective, trying not to confuse them, because of course each one of the perspectives has its own logic and the history and the legal philosophy behind it. But I have indeed been asked with all of that diversity that characterizes Europe, and also with an incredible detail and in-depth that the courts operate with, our courts operate with, I have been asked nevertheless to share with you these reflections on the future challenges. Now, given my topic, you will excuse me that I will not go into, the nitty-gritty aspects of law, and my concluding talk, in a way, will be of a more general nature. Now, there are many things in Europe that we take for granted. Even the war waged by the Russian Federation against Ukraine, the war on the European continent, has not, in fact, much affected this feeling of general peace in the large part of Europe, of the kind of permanence of human rights, democracy, and rule of law. Most of the time, we do not reflect back on the history and sacrifices that have allowed Europe to first conceive the ideas of human rights, democracy, and rule of law, and second, have the rules and the mechanisms that enable the practical implementation of these ideas. The fact remains that modern-day Europe, with effective regional organizations such as the Council of Europe, spoken a lot today, and the European Union, also spoken a lot today, as well as plenty of sub-regional and supra-regional organizations, is an outcome of some of the deadliest wars Europe had experienced over the centuries, and the ensuing promise, never again. Values at the center of European identity, as are the result of its long and violent history, and the search of the intellectuals for the alternative ideas to aggressive power. There is indeed a European identity, even if today panels have focused more probably on differences, on freedom to invoke national particularities, or even there have been also suggestions of the absence of constitutional identity, which brings forward to the forefront concerns that somehow these identities can be affected by what I call a European identity. I will therefore address the relationship between European identity and national identities, and I will share my view on the role of constitutional adjudication in Europe in this regard, which of course requires to define what is constitutional adjudication in Europe. Now, we define identities through values that unite a people at a national level, national levels. But today, we also define Europe based on values that are common to our European nations. This is a particularly complex choice, and I do recognize that. But we have come to make that choice in Europe. And so the question really is, how do you come to share same values among peoples who are shaped by different histories, language, climate, geography? Is this choice sustainable, both from within, but also against the attacks from outside? And that is the question of today in Europe for everybody. Now, European identity is best described in the preamble of the European Convention on Human Rights, as well as the Statute of the Council of Europe. The Convention confirms the profound belief of Europeans that fundamental rights and freedoms are the foundation of justice and peace in the world, and are best maintained on the one hand by an effective political democracy, and on the other by a common understanding and observance of the human rights upon which they depend. It actually points out that European countries are like-minded and have a common heritage of political traditions, ideals, freedom, and the rule of law. According to the Statute of the Council of Europe, peace is based upon justice and international cooperation, while the true source of individual freedoms, political liberty, and the rule of law are the common spiritual and moral values of European nations. It is primarily a European view that democracy, development, rule of law, and respect for human rights and fundamental freedoms are interdependent and mutually reinforcing. Even if this view has also been placed in the center of human rights work in the United Nations since the World Conference in Vienna in 1993, international law as such does not impose a particular form of government on states. And so the requirement with detailed corollary obligations in that a state must be democratic with strong independent courts is a matter of European law, comprising both the Council of Europe standards as well as the EU law. And it is this view that reflects the European identity. European Union has gone beyond the idea of international cooperation seen in the context of the Council of Europe and represents the next level of integration of 27 European nations at this stage. It is important to keep in mind that at some point during the process of building common market, and Advocate General Spooner referred to that, and I will complement, the common market as the original aim of the European communities at the time, those in charge of this process had realized that common market is not neutral in terms of value choices. To take a simple example of the ECJ case law, business would probably survive with considerable differences between workers having a permanent contract and those with part-time contracts. However, something in the European culture was telling that we are not too pleased leaving the matter completely in the hands of raw market forces. And so the legislator, the complex legislator of the EC at that time, and subsequently the court, addressed the matter in terms of equal rights. Since there is a long history of distinctions drawn between different peoples in Europe, men and women, property owners and those without, citizens and non-citizens, people of color and others, and that these distinctions, mostly based on stereotypes and fear, have fairly often led to the most horrible crimes in Europe of today. We look at any distinctions with great suspicion. And so also in the field of common market, the integration of the nations soon moved into the search and agreement on common values, which are now contained, and it has been mentioned, in Article 2 of the Treaty on European Union. Article 2 reflects the shared values of the members of the European Union as follows, and I think it is worthwhile to cite the article. The Union is found on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between men and women, between women and men actually, prevail. The institutionalization of these values, which find their concretization also in the EU Charter of Fundamental Rights, has given rise to important case law, holding the EU institutions and states accountable for non-compliance with Article 2 values. They are justiciable. This accountability process both increases the rights of individuals and improves the rule of law in Europe. The European Union has clearly confirmed that economic integration and free market also requires common values that are legally binding and transcend common economic solutions. Such a view of the functioning of markets also characterizes European identity, at least for the purposes of the functioning of the European Union. The formation of European identity, at least in a number of dimensions I have mentioned so far, has been a long and multifaceted process. The roots are in the history of ideas that have been responding to all the events in the European history generated by men within the states and as between the states. The identity has been shaped by national constitutional traditions, and I will come back to that, and through intergovernmental processes and negotiations. I should say that the European identity has been hard tested and truly has its legitimacy. I have argued elsewhere that legitimacy of the European identity cannot be taken for granted either. It requires a constant attention by all those competent to pronounce on it. And we have discussed all of those actors. First of all, it is the Court of Justice and the European Court of Human Rights. Within their respective competences and in view of the particularities of the legal systems which effectiveness the two courts ensure. Most notably, judicial pronouncements on European identity happen when the Human Rights Court, as part of the method of interpretation of the Convention, takes stock of the existing European consensus. It is true that, on the one hand, European consensus is a technique of application of that international treaty over time, in view of the fact that society is a living body and therefore evolves constantly. On the other hand, it reflects common values that evolve and change over time, and in that, European consensus describes European identity of that moment within the ever-changing societal processes. We change as we speak. We have changed even today in this room. Within the European Union, the very engine of the integration is fueled by the dialectics of the relationship between diversity of the EU member states and their unity, which is articulated through the very nature of the EU law. Common constitutional traditions are a source of general principles of the EU law, and general principles are a primary source of the EU law. But it is also means of interpretation of the EU Fundamental Rights Charter. And therefore, you see that common constitutional traditions shape the identity of the European Union, which is part of the broader European identity. In all of these legal concepts of the human rights system or the EU law, one sees the connection with the processes in the European societies, and that ensures legitimacy of the regional and supranational decisions. The fact that national identities are to be respected and are, in fact, part of what makes Europe what it is today is best reflected in Article 4, indeed, of the Treaty on European Union. And I quickly just point out to you, point 1 mentions that in accordance with Article 5, competences not conferred upon the Union in the treaties remain within the Member States. The Union, point 2, shall respect the equality of Member States before the treaties as well as their national identities, inherent in their fundamental structures, political and constitutional, inclusive of regional and local self-government. Point 3, pursuant to the principle of sincere cooperation, the Union and the Member States shall, in full mutual respect, assist each other in making the Union function effectively and making it real. Now, in the convention system, such principles as margin of appreciation and subsidiarity, as well as the very principle of the accepted restrictions on human rights, Judge Iociene already referred to, where a legitimate aim and proportionality has been respected, give space to national identities, subject to verification by the Human Rights Court, as the case may be. It is therefore obvious that what makes European identity are national identities, and that the fine dialectics between maintaining differences and building on common values. This is a fundamental part of legitimacy of the entire European project, and especially it is, as you could see, a key pillar for the European Union. Now, what about the courts in all of it? The idea of dispute resolution by an independent authoritative party also accompanies the development of modern Europe. However, and we should not forget that, submitting modern states to permanent international courts is to be seen still as an ultimate achievement in the evolution of ideas and a counterpoint to abuse of power or absolute sovereignty. And that is an aspect of European identity. In the final part of my speech, I will use concepts such as European judiciary, which denotes all the courts in Europe that form a web of judicial interrelations within a common legal space. I denote European courts, the courts that are international and supranational, the two European courts, and the notion of courts in Europe refers to the numerous individual and specialized courts that are essential for the functioning of the European system of governance. I've developed further these notions in a Oxford University book that is coming out actually this summer, on a handbook on international law in Europe, for those interested. But what is important to see is that from the perspective of the EU law, Article 267, already mentioned by Professor Huber, of the Treaty on the European Union, which deals with the preliminary reference procedure, and Article 19, which, according to the case law of the Court of Justice, gives concrete expression to the value of the rule of law stated in Article 2, entrusts the responsibility for ensuring judicial review in the EU legal order, not only to the Court of Justice, but also to national courts and tribunals. So the courts, all of our courts, no longer operate in isolation, but carry a common, and I cite Professor von Bogdandy, but carry a common legal responsibility for the European legal space. For that reason, the principles and standards applicable to the functioning and composition of the courts have gained such a preeminent importance in both European courts, the European Court of Human Rights and the Court of Justice. The independence and impartiality of all of the European courts have become vital elements of European judicial architecture that most of us belong to in this room. And so it is for this reason that a common standard of independence and impartiality of the judiciary has been reinforced. Now, the regional courts' role and interaction with national courts have reached another level in Europe. It can indeed be designed as a union of courts that perform constitutional adjudication, or in the words of the former president of the German Constitutional Court, Andreas Voskuhle, we are talking about Verfassungsgerichtsverbund. I would add to that saying that, in fact, European courts in Europe also form a community in the application of the EU law and the common legal responsibility for European legal space. Because of these developments, we can now talk about a web of close mutual relations through indeed formal and informal procedures and communications, including telephone calls between Karlsruhe and Vienna, judicial dialogue among courts in Europe, which forms a real and complex architecture of what can be termed the European judiciary. And you are a picture of that today here in Riga, which has a primary aim of protecting individuals against abuses of power and protecting individuals from each other to ensure peace and development. It has been rightly pointed out, and I cite again a good friend of mine, Professor von Bogdandy, that Europeanization has reshaped courts performing constitutional adjudication and continues to do so. Today, these courts are not only responsible for securing the respect for their domestic constitution within their own legal order, though this remains their main task and the basis of their legitimacy, but are also called upon to contribute to the orderly functioning of the European legal space. Constitutional courts and supreme courts performing constitutional adjudication have a particular responsibility within and in the name of the European judiciary, since they have the final say in triggering the dialogue mechanism. That is of crucial importance for the development and viability of the European judiciary, and that was one of the questions today. It is in this context that the idea that courts performing constitutional adjudication both at European and national levels should engage properly with the protection of Article 2 TEU values, which embraces, by the way, the minimum human rights standards as set forth in the European Convention of Human Rights. And that sort of a key issue, how to embrace, how to deal with the common EU values, that is the challenge now and for the future. How do we do that together as a plural body, evidently? Now, the conditionality cases of the Court of Justice were already mentioned. I would say that these are the judgments where the Court of Justice really did show how Article 2 values are judicialized, that they are not really abstract statements or wishful thinking, so they are applied. And it is in that context, we were concerned with the rule of law value, but it is in that context that the Court of Justice, for the first time since Van Genden-Loss, I should say, gave a definition of what is European identity. And it did say, I quote, "The shared values as stated under Article 2 TEU define and lay out the very identity of the European Union as a common legal order." And the emphasis is on common legal order. And that elevates the courts to a particular responsibility in Europe. And that actually shows that it is not only for the politicians and the parliaments, it is for the judges and the courts as well to be responsible for building the common legal order. So in its reasoning, and that is pertinent to current condition, the court stated that the European Union, in case of breach, should be able to defend the values of Article 2. And it is here that you see that the principle of self-defending democracy is also part of the European Union legal order. Now, it is this basis, the combination between Article 2, Article 267, Article 19, that is the basis for the proposition that constitutional courts and all national courts also have the competence to ensure the foundational EU values, that the foundational EU values are respected if the case in front of a court raises that issue. And then procedurally, that can mean several options. Now, to conclude, Europe shows how the evolution of ideas about better ways of governance to ensure peace between nations materializes in several key concepts, such as human rights, the rule of law, and separation of powers, of which implementation requires an independent and impartial judiciary. The European legal space has responded to historical challenges by creating a house with several Supreme Courts which overlap in their jurisdiction. We have had in the doctrine arguments that mutual relationships among these courts are not satisfactory, clear, or convincingly established, as each one of them indeed belongs to these different legal orders and systems. Now, the principle is that none of the courts is a Supreme Court of Europe. That is actually, as by now you see, not the idea characterizing European legal space. It is Article 267 of TFEU, as well as principle of subsidiarity, which transcends both the convention system as well as the EU legal system, make all courts in Europe responsible for upholding common values. Europe's foundational idea of unity in diversity is the balance that each court must strive to achieve when carrying out its respective competence. This is both a challenge at the technical level of adjudication, and the examples were mentioned today of a dispute, but it is also, and that's what I would like to emphasize, a unique, absolutely unique in the world opportunity because for the first time in Europe, the centuries-old idea of unity among European states takes place in reality, and the courts have been elevated to play a major role. That is, compared to everything else that happens across the planet in different continents, that is an incredible achievement. So the European judiciary has taken a central stage along with political and legislative processes in Europe in substantiating and implementing the idea of Europe as a space of peace, prosperity, and values. This takes place through the search and deduction of general principles of law. It can be argued that the principle of mutual trust, and that's my proposal for the future, as defined in the EU law, requires further conceptualization and has an incredible potential, I should say, to explain relations within a European judiciary as well as the EU member states and impact wider Europe, the one that is subject to the ECHR system. And by conceptualizing further the principle of mutual trust, we have the ways to bring forward the construction of Europe more than ever before. Now, we accept that mutual trust derives from the foundations of the EU legal structure. And in that, we see that the European Union has added a new layer to the principle of state consent as the basis, with no traditional basis for the construction of international law, that is the system of the Council of Europe. Europe constructs common rules not because it is in the self-interest of each state, which has typically been the way international law is shaped, but within the European Union, the rules are shaped because there is a mutual trust in each other, in that we share a common view of how rights of the citizens should be protected. Mutual trust paradigm cannot be achieved without strong national courts protecting human rights and rule of law, including the Convention as a minimum common European human rights standard. Now, I believe these are the foundation blocks for the new kind of legal space in Europe, in which a new kind of legal order, getting inspiration from Van den Los, a new kind of legal order of the EU is a central element. But the leap from cooperation as an element of international law to mutual trust, as experienced by the European Union, is not easy. It requires a considerable evolution in culture and in true belief of equality among states, irrespective of our size or history. It requires also acceptance that we all have the right to be different, for as long as that does not affect the mutual trust. And so in that context, the future continues to bring numerous challenges. Now, the next stage of the European judiciary's evolution would be to fully accept that it is a single and unique web of different but interlinked courts with the same purpose: to ensure peace, protection of human rights, and prosperity in a common, multi-layered European legal space. And I hope we will achieve it sooner than later in Europe. I thank you for your attention.
Ineta, sincere thanks for bringing the future perspective into our conference. And now I kindly invite my colleague Martin Paparinskis, who is Professor of the International Public Law at University College London, as well a member of the United Nations International Law Commission, to share with us concluding remarks of our conference. Martin, please take the floor.
It is a great honor and privilege to be introduced by the President of the Constitutional Court and to be on the stage with the President and the former President of the Constitutional Court. I have, of course, been given an impossible mandate. We have heard discussion of incredible richness, interrogated, pushed and evaluated within its particular panels, conferences have layers as onions and perhaps other less aesthetically appealing creatures for those who appreciate the reference. So in my 19 minutes, I will try to tease out the differences and identify things that struck me as particularly important for further reflections. As Ms. Vitol noted, asking questions is a sign of a healthy mind, although I cannot help but feel that sometimes the content of the questions might also be a relevant consideration there. So I propose to share with you 6 groups of questions. First, in relation to metaphors. Speakers were wonderfully poetic, and I think it does tell us quite a lot about both the type of reasoning that is engaged in these issues and the sort of broader mental map on which we can situate these important considerations. I will then say something about vagueness, again a concept that ran through our considerations. I'll have 3 particular things to say about the panels, and then I will have 3 issues to leave you in conclusion. So let me start with metaphors. It is perhaps not surprising that they were so rich. Professor Huber reminded us that we are building on almost a millennium of discussion of the great questions of political theory and philosophy about the ordering of institutions in Europe. So it is not surprising that there is a rich pedigree and heritage within which we can situate ourselves. Some of them related to transport. Judge Queer spoke about a metaphor of a navigator, somebody who can guide us and sometimes tell us that we should turn back. Although, of course, in the context of this particularly well-equipped conference that has driven us around, there's also the possibility of a metaphor of a person who is seated in a car and has only a choice to command the driver. So there might be a challenge explored in that regard as well. Judge Kuch spoke about consensus not being a one-way street, an important proposition, although as we know, one-way streets also serve a good function. They can lead to such wonderful venues as this one. And they may also lead to dialogue between drivers. My good colleague and friend, Professor Letzes, noted the perils of that perspective, although that, of course, also depends on the institution. We spoke about courts, but courts are not the only way of settling disputes, also at the international level, and there may be institutions that are more dialogic than confrontational. Judge Queer also made the metaphor of a translator and a hinge, which struck me as very insightful, and I returned to it at the very end. It's an important proposition. We all translate. We all speak somebody's foreign language, so there needs to be both sensitivity and subtlety in that process. We spoke about courts. There are many judges here, and I think it's important to clarify that and confirm that Professor Genciaro's reference to false friends does not relate to courts. Courts are only true friends to each other. Many metaphors fell on anthropomorphic conceptions, on concepts, on institutions. Professor Huber spoke of having 2 hearts. One reminiscence is, I suppose, of Ernst Kantorowicz's famous work on King's 2 bodies, body natural and body politic. Professor Huber again noted rightly that we were only human at the same time. Deciding on matters gives sovereign powers. Judge Queer spoke of institutional personnel. I suppose international lawyers in the audience might think of George Sell's famous notion of the doublement fonctionnel. One of the most prestigious books to be read at the moment is Xiantiu, the famous 3-body problem book. And of course, Ms. Vitol reminded us of 2 sides of the same coin, although I do wonder whether in the banking metaverse that we were told of, there will still be 2 sides of the same coin. It's almost a Zen kind question whether one hand can clap, whether one court or coin can interact with each other. So that's about metaphor. And I think when speaking about dogmatics and final legal points, it's worth also stepping back into artistry and reflecting on these broader issues. The second bigger theme, a metaphor of sorts as well, relates to vagueness. This is something that Judge Lavinch began with, and Judge Gnatowski talked about a lot. Professor Huber, with a nod to the important aspect of multilingualism in European judicial architecture, mentioned a Napoleonic phrase about the importance of constitutions to be cure obscure. And Professor Gesiaru spoke about the degrees of vagueness. I think in discussion of vagueness, I have often found helpful to distinguish between two meanings of vagueness, ambiguity of vagueness, if you will. Vagueness as something opposed to concreteness, and vagueness as something opposed to ability to convey meaning. These are different things. There are things that can be concrete and lacking in meaning, and there are things that can be lacking in concreteness and very meaningful. So I think if we think through challenges of vagueness, we have to be clear which of those we are reflecting on. Vagueness is not necessarily a bad thing. Timothy Endicott has famously argued for the value of vagueness. Vagueness is wonderful. I argued last summer in the International Law Commission to my colleagues to reflect on the value of vagueness and cautioned against refinement of taxonomy for its own sake. I have to say on the particular point my colleagues did not follow my suggestion, but I think that the point stands nevertheless. Now, one response to vagueness is dialogue. Judge Lavinch invited us to a dialogue, and of course this is a wonderful dialogue. There are also some challenges raised by other speakers. So dialogue requires speakers. Judge Kuyer noted that Dutch constitution is sometimes a bit taciturn, so can we have a dialogue when one side is slightly understated? German constitution, though, we heard, speaks, so there are a variety of dialogues going in Europe. Another concept of a certain degree of vagueness is legitimacy. The great and much missed James Crawford warned us about the caution of legitimacy speak if it is something that is a slightly fuzzier notion of law that we feel a bit more comfortable with and a bit less precise with. I don't think that that is the way how it was used, but I think it's worth noting nevertheless that legitimacy is not a free-for-all. It is a normative conception that requires normative justification and explanation. And of course, dialogue can give an answer to some questions. The philosophy of language teaches us that there are concepts that are essentially contested, where the exercise of contestation is part of the concepts themselves. We feel deeply about them. We are angry when we are challenged on them, and we will not reach a consensus. It is precisely greater disagreement that is a reflection on these matters. And on some of these points, it strikes me that we are speaking about essentially contested concepts. On constitutional identity, they might be going back to the very foundation in late medieval Italian northern towns of the autonomous identity not governed by singular, secular, or religious authority. Judge Ziemele just noted that for the first time in Europe, the centuries-old idea of European states takes place in reality, and the courts have been elevated to play a major role. Now, without taking a position on the argument, if that is right, we should not be surprised that the contestation will be a fundamentally contested one. Indeed, disagreement is precisely what should be taking place. We are doing exactly what the broader argument pushes us to do. Let me now move and say a few things about the first panel on the national constitutional identities and the variety of ways in which they can become relevant. Judge Kuyer said that it is important how constitutional identities are invoked. He was pushed somewhat by Judge Otsiene whether it meant that the identities were not important, and he explained that that was not what he meant. They were important, but hard to pin down and varied in country from country. Therefore, dialogue interaction between institutions, deference. Judge Gnatowski referred to margin of appreciation. I have jotted down as everything that we have for addressing certain issues would be one way of looking at it. So institutional relationship rather than necessarily the content of the rule. Advocate Generals Bunar suggested that courts, if they want to be more influential at the European space, should refer more cases. And Judge Petrucella supported that call. Some people were not enlightened by the discussion. Professor Getsiaru felt particularly unenlightened. Professor Letsas even thought the concept either superfluous or pernicious. Judge Kuyer explained the concept as going, I think, to certain foundational assumptions, perhaps a sort of the background rules of the constitutional order, which struck me as somewhat similar with the expression that the International Law Commission chose when explaining general principles formed within the international legal order, using the adjective intrinsic. Principles intrinsic to international legal order. So perhaps that is one way of looking at it. Judge Otsena had a clear answer. In Lithuania, constitutional identity is listed in the constitution. And Judge Ziemele also explained the fine dialectics that are foundational in that project. There are other ways of looking at it. Judge Gnatowski noted that at the end of the day, constitutional law argument does not excuse a breach of international law. And Judge Kuyer noted, I think, similarly, if expressed as an argument of sovereignty, something distinct from constitutional identity, it is inadmissible. And that must be plainly right as a matter of public international law, the customary law expressing principle in Article 3 of the 2001 International Law Commission's Articles on State Responsibility, although it's worth remembering Commentary 7. Domestic law is irrelevant for international responsibility unless international law makes it itself relevant. Judge Gnatowski also spoke about the importance of translating constitutional identity arguments into something that can be understood within the parlance of European Court of Human Rights. Very important point, and I will return it to the very end. And he called for broader engagement with other rules of international law. Strasbourg Court, he suggested, was an international court, with which I would agree, but also international courts have limited jurisdiction, as was reminded on 2nd of February by another court based in the European continent. And of course, constitutional identities may be formal sources of international law. General principles, customary law, interpretation. Judge Ziemele already referred to that. Let me move on now to my fourth point, and I think this one I can make fairly briefly, and it is just to say, perhaps with a degree of caution, about defining European values as such that are peculiar to European region. And so I think the sense that peaceful settlement of disputes, human rights and justice are unfamiliar or not foundational in other regions and other regional organizations might be something that we should pause before considering. I was just having a look at the foundational documents of the intra-American, African and ASEAN regimes, and I don't think that that is something that would be entirely right. Let me now move to the second panel that is in our vivid memory and that spoke about consensus. And of course, from public international law perspective, there are many ways how consensus can be captured in internationally relevant terms. Judge Ziemele has written a very influential piece a couple of years ago on how within the Strasbourg setting consensus could perhaps be conceptualized as a rule of regional, particular customary law. And within the International Law Commission, certainly consensus is of great value. I was quite pleased that last year as a chairperson of the drafting committee, we did manage to adopt all the conclusions by consensus, and that is something that states are very appreciative of. So there are also contexts where the precisely right answer might be less valuable than the broadness of endorsement and the weight of authority. Again, of course, International Law Commission is not a court, but it is something that is not entirely, in some respects, unlike a court. There were many subtle points made in the second panel. I think if I can draw all of them together, for me the takeaway was that consensus works in wonderfully different ways it's wonders to perform. It may work differently in different institutions, at different periods of time, in relation to different subject matter and different issues. There was deep but very respectful disagreement between Professor Jasiaru and Letsas. Judge Kuch explained the domestic perspective in these matters, Advocate General Zbunar, the Luxembourg perspective, and Professor Letsas and Ms. Vitol spoke about the Strasbourg perspective. So again, a great deal of overlap, a great deal of subtle interrogation of particular cases and conceptual aspects. All right, well, I have been making wonderful time. I have 3 minutes, and I'm with my concluding points, which will be 3. 2 will be serious, 1 will be not, but I will let it for you to decide which one is which. First, I think that one broader takeaway is that we spoke today about Europe in her shared values and in her infinite variety. That, I think, is not a contradiction. There were very different views on what it is that is shared. Values, at least a certain degree of abstraction, certain institutions, certainly ways of thinking and reasoning about things. Clarity about questions, but equally acceptance of the possibility of both respectful, as I suggested in the beginning, very heated disagreement. There's nothing wrong about heated disagreement when we talk about issues that we are concerned about deeply. Clinical removal from things that matter is not what lawyers necessarily should be about. For example, I thought that it was very interesting to note the different reactions to the invocation of the work of Vod Bogdandi. Judge Petrucella and Judge Ziemele were approving, and Professor Huber significantly less so. So these are hard questions. On an entirely different topic, I was reminded of a remark by James Crawford that where he stands depends on where he sits, but that is a different discussion. The second point I want to make is an expression that some of you may be familiar with, and that was perhaps a slight danger of some arguments, the so-called the law of the horse. And I quote from a particular article. Lots of cases deal with sales of horses. Other cases deal with people kicked by horses. Still more deal with the licensing and racing of horses, or with the care veterinarians give to horses, or with prizes at horse shows. Any effort to collect these strands into a course on the law of the horse is doomed to be shallow and to misunifying principles. And that, I think, is one way of looking at the disagreement in these panels between those speakers who felt that possibly there's an element of the law of horse going on in their assignment. Judge Gnatowski, I thought, was a particularly strong exponent of that thought on the first panel, and A.G. Zbunar and Ms. Vitol particularly in the other. And others felt that this was a coherent subject matter. And I think that there are reasonable ways of thinking about it, but that is a helpful way of doing it. Thirdly, and final point is that law is a language and a style of argumentation. And here I come back to Judge Queer's point about translators and hinges on what the system turns on. There are arguments that work in some courts but not the others. Fitzmaurice, in Tyler's example, who did not work at all, well, might have worked in the International Law Commission, International Court of Justice. And again, it's such an honor to be on the stage with Judge Ziemele, who has excelled in her legal argumentation in 3 courts. All right, I was a bit stricter with myself than others. So let me finish on the last paragraph. Oscar Wilde's Gwendolen, in Importance of Being Earnest, said, "In matters of great importance, style, not sincerity, is the main thing." And then she added that absence of belief in the man does not affect the wonderful beauty of his answer. Oscar Wilde, I think, may have slightly overstated it, but I think what we have heard from today is that both style and substance are important. And what is particularly important is the place of judges on law and courts in the evolving society. I could not agree more with Professor and Judge Ziemele's concluding words about the place of law in the evolving society. And I can finish with what strikes me as the most poignant last sentence in the International Law book, in Von Lowe's International Law. When all is said and done, sometimes it's better to ask for assistance not from a lawyer, but from a priest, a doctor, or a plumber. Thank you, President Lavinch.
Thank you, my dear colleague Martins. I admire your ability to prepare such a professional concluding remarks. Thank you once again. So, dear colleagues, now we can move on to our final topic, let me say in this way, final point of our program. But before I say closing words of this conference, I want to stress that for the people of Latvia, it is immensely important value is Latvian language. That's why I open this conference and I close this conference in my native Latvian language. That's why I kindly ask you to use headphones. Cienējamie kolēģi.
Dear colleagues, our rather exciting conference is drawing to an end. I had pleasure of being with you and being part of this exciting and quite thought-provoking discussion, and I'm thoroughly pleased about what we have achieved here together. So, this is now the point where I have to also briefly, on my behalf, highlight some of the takeaways that I have, takeaways about complex notions such as European consensus, European values, national constitutional identity. When we encounter these challenging notions or challenging paradigms, I do believe that we have to follow the recipe that was mentioned by somebody during today's conference, a recipe for success when it comes to overcoming these challenges that we face. And the recipe is rather straightforward. Just listen to each other. And not only listen to each other, but hear each other. So this is absolutely crucial. It seems a very simple recipe and very straightforward, but very potent, I would say. So let me, from the bottom of my heart, thank everybody who made this conference possible. Thank you for hard work and for your contribution. And throughout the day, the Latvian team has been praised over and over again about the successful organization of the conference. And it is only fair that we now also thank the people who are responsible for the success of this conference. So on behalf of the Constitutional Court of Latvia, I would like to thank, first and foremost, the organizing or the steering committee of the conference, which together with the justices of the Constitutional Court worked on the content of the conference. And I would like to thank the legal department, Kristaps Tamush in particular as the director of the department, and my advisors, the head of the administration, Marika Laizana Jurkana, and also the advisor, Andrei Stupins Jägers. And I, as the President of the Latvian Constitutional Court, would like to thank every one of you, every colleague from other constitutional courts of Europe, and I can only wish you would have the same team as I do, and I already miss you, in fact. So, would like to thank our experts as well, whom we approached and who all of them, by the way, agreed to take part in today's conference, reinforcing our initial vision about this conference. So I would like to also thank you personally, every one of you. I would like to thank Martin Kuja. I would like to thank Mikola Gnatkovsky, Peter Huber, Konstantin Dekterev. I hope I pronounced it correctly this time round. My colleague Artur Skuch, Maciej Špunar, George Letzes, Professor George Letzes, Eline Louise Vitola. Eline, thank you from the bottom of my heart for being open, and really the openness that you brought into this room was absolutely outstanding. And Inet, as usual, you are the biggest friend and supporter of the Latvian Constitutional Court. And Martin Paparinskis, thank you. Whenever we need support, we know where to find it. Thank you very much. I would also like to thank the small guild for hosting us. Wonderful acoustics that I suppose you all enjoyed as we discussed the topics of today's conference. As we sang the anthem of the Latvia, and which resounded loudly across this room and gave the inspiration for the conference and gave us the energy to last the whole day talking about such complex topics. Would like to also thank the Constitutional Court team of the Constitutional Court of Latvia, in fact, to organize or to bring back the tradition of having this conference in the beginning of year. We had to work hard, in fact, for 5 months in order to bring this to you today. And I should say that the last week was something. So we had to work extra hours late at night, and quite often, I was leaving the court and my colleagues were still working, or I came here and I met my colleagues here, working here late night. And I should say that this Thursday we also had another international event. We had the Baltic Trilateral meeting between the constitutional courts, and we met with our colleagues from Estonia and Lithuania to discuss our current priorities and our current agenda, and our team, under short notice, was capable of organizing 2 major international events, so kudos to you. And I would also like to thank our technical staff and thank the technical staff for providing technical support throughout the day. As regards to catering and other organizational matters, I would like to thank the Executive Director of the Constitutional Court, August Stintmans, for dealing with all the housekeeping, who oversaw the catering for the 2nd year running. He's part of our team, and I can always rely on him as the President of the Constitutional Court, and I know that everything will be done and will be top-notch, so thank you, Aigars. And, dear colleagues, as I already mentioned, as soon as one conference is over, as one has as soon as one international conference is over, we are already looking forward to the next conference or moving over to the next conference, and would like to invite you today to the next year's conference that we will host together with our Ukrainian colleagues. During this conference, we will talk about our common future in united and safe Europe. But meanwhile, there's a homework to be done, dear colleagues. So we need to also decide how to restore the international rules-based order. So that is the task that we will have to address 2 weeks from now as we meet at the World Justice Conference at the World Conference on the Constitutional Justice. And thank you for the endurance, and hope you enjoy tonight in the Riga that is already taken over by the spring. So thank you all.
Dear international guests, I come to you as a relief